Says that under compelling circumstances, I'm mentioning a matter that this is the matter where Millard on 28th of August, Supreme Court directed to file the list of tainted can. On 29/8, provisional admit card was issued in my favor to appear in the examination. Then on 30th of August, without informing any reason,
Yes, yes. What do you want?
Millard, I want that this matter, Millard, if your lordship grants a
How many matters are there?
I have one matter. I do not, but one matter, but three bunches because of the list of the orders. Now, Millard, a rule has been made that I have to make.
You have to appear on which examination? 7th or 14th? 7th.
14. I'm sorry, Millard, 14.
14. Mention on Monday.
May I say one thing? May I say, because I should not say anything more. Millard, I heard that this is from my learned friends that yesterday one matter was taken up by my.
One matter, more than one matters.
Now, my lord was pleased to dismiss the matter. Now, my lord, I told my learned junior that the law is that if one matter has been, an order has been passed, unless it has been found that there are major irregularities, or rather say there are discrepancies in the matter, judicial propriety demands same order has to be passed. Therefore, so that I can avail of my.
No, Mr. Bhattacharya, I am hard-pressed because I am also having determination of another bench. Since your examination is not on 7th, mention on, tell your junior, mention on next Monday, file it tomorrow. It will appear on the fixed date. If necessary, if I cannot read, I can upgrade. Sorry. Yes.
May I say one thing? Only one
Yes.
thing. There are two admit cards. One is on 7 and another is on 14.
So don't mix it up.
No, this has been, Millard, the petitioners.
Those matters which are where examination is fixed on 7th,
Yes.
only mention those matters.
Millard, I have 7. This matter.
But in other matters, suppose there are 10 petitioners in one matter.
Yes.
5 are going to appear on 14th and 5 are going to appear on 7th. Then bifurcate it. Yes.
I apologize for mentioning.
Yes.
I apologize for mentioning today. Yesterday, the matter was appearing as item number 144. This is a matter between the tainted and untainted matters. Lordship, today the matter is not appearing, Lordship.
Yes, tomorrow it will appear.
My lord.
All matters which I have allowed mentioning, I have instructed my officer to appear on
Grateful, Lordship.
tomorrow.
My lord, there are 4 matters. My lord, I am please pass leave.
Yeah, I have
leave
allowed
to
your
file.
mentioning.
Leave
Yes.
to file, my lord.
Contempt application order.
Don't mention today. Contempt application mention on Monday. Why you are mentioning? Monday is these are all urgent matters they are mentioning.
My lord, please.
Try to appreciate the
Please
position.
allow leave to file, my lord.
But I have
4
allowed
matters.
your mentioning. And more than one matters. Why again you are mentioning? There are other matters. When the examination is date is fixed. 7th. Tomorrow, how many matters are there?
4.
Only 4. Tomorrow.
My lord, I have 2 matters regarding the second SLST, my lord. I have 2 matters regarding second SLST, my lord. By mistake, they choose the wrong subject, my lord. That's the reason. 7th is the examination date, my lord.
Sorry, it's not possible.
Kindly, my lord. Otherwise, the
Please call the
petition is.
list. Please call the list.
My lord, otherwise the petition is deprived, my lord.
This is a part-heard matter of Mr. Justice Vishwajit Basu, Master.
I have released this matter.
No, my lord. This is another matter, my lord. And the exam is 7th.
Sorry.
My lord, this is very urgent, my lord.
No, if it is part-heard, sorry.
My lord,
Sorry. If it is part-heard, don't mention.
My lord, kindly allow
Yes.
this. My lord, kindly.
No.
Kindly, my lord, allow this because the petition is.
Yes, please call the list.
kindly keep it with
No further mentioning. Please call the list.
item number 1.
I cannot satisfy you. You will go on mentioning. I have tried my best. I cannot satisfy you. Sorry. Yes, call the list. Today is not the date. Mention on Monday. These are the matters where examination is fixed on 7. Yes, call the list, call the list.
Item number 1.
Am I allowed to take a leave?
Please call the list, no further mentioning.
My lord, I am appearing on behalf of the state, my lord.
My lord, I am appearing on behalf of the petitioner. My lord, there is a
Yes, come
small
for correction.
problem
What
in the
correction?
typographical.
My lord,
Yes.
petitioner
That
is
is only the correction in the name of the.
What correction you
first name.
require? What correction is needed?
My lord, my lord, the name is Mitali Odhikari versus the state of West Bengal and others. It was mentioned as Jadavpur University. That's all, my lord.
State of West Bengal and others.
state of West Bengal.
Respondents would be state of West Bengal and others.
Yes,
Do you
my
hear
lord.
me?
Yes, my lord.
Respondents would be state of West Bengal and others
Yes, my
instead of
lord.
Jadavpur University.
Yes, my lord.
Matter has come up in the list under the heading to be mentioned, quote unquote, for correction of order dated 26th August 2025. Next paragraph. Inadvertently in the cost title of the order, Jadavpur University and others, quote unquote, was described as respondents instead of state of West Bengal and others. Stop. Respondents shall be read as state of West Bengal and others instead of the university and others, quote unquote. Department is directed to incorporate necessary corrections. This order forms part of the order dated 26th August 2025.
Item number 2.
Same thing.
Same. Jadavpur University.
Achha.
Same order.
State of West Bengal and others, একই করে দেবে। 26th August 2025 order. Same.
Item number 3.
Yes, my lord. It was
Instead of Jadavpur University, it would be the state of West Bengal and others.
না করে দেখা সম্ভব না ওটা এটা মানে আমি দেখি শেষ করতে পারবো একসঙ্গে করো সেটা বুঝবো না কেমন
Item number 4.
May it please my lord, I beg to appear online in this matter.
Led by Mr. Rahul Bajaj, who is appearing virtually. Kindly.
Yes. May it please my lords, may I submit? I am appearing online. Lordship, in this petition, I am aggrieved by the fact that I represent a series of blind and low vision teachers who are appearing for the SLST 2025 exam. They are aggrieved by the fact that the number of declared vacancies, in particular for classes 9th and 10th, have substantially fallen down from 2016 to 2025, which is contrary to my Lord's judgment. In the Sanjoy matter, I will just show, as also the RPWD Act, the Rights of Persons with Disabilities Act. If my Lords may kindly come to running page
now whether
434.
you have applied, whether the petitioners are applied.
Yes, Lordship, we have applied for the examination. We are
So
not
what is the
seeking.
urgency that today matter has to be taken up? Let them appear.
I have already served upon them.
Lordship, the only point is
Let
this.
them appear. Point is to be
Yes.
decided whether the number of vacancies reserved for persons with differently able candidates would be enhanced or not. That will be considered later on.
I am grateful. I will only submit this, that it was important to appear now, because after we have sat in the exam, it will be said that now we cannot challenge it. So
No, but
therefore, if
you have filed it. Court has accommodated this matter in the list.
yes.
So
So if
therefore,
my lord,
this challenge, this point of challenge would not be available to the respondents.
yes,
It is not that after participation you have come.
correct. I follow. Just
So
2
once you
points.
have applied,
Yes.
I was under the impression, Mr. Counsel, when your
Yes.
junior mentioned this matter, that you are debarred from participating in the examination.
No, that is
fact
not
you
the case.
apply. But suppose a number of vacancies earmarked for person with disabilities is determined as 50, but according to your appreciation, it should be greater than 50, higher than 50.
Yes, yes,
Then that is a case which does not require early hearing,
yes. So
considering
I'm,
date of examination, when the date of examination is fixed. 7th,
yes, 7th onwards. Just I
yes.
follow. Just 2 points I'll say. One, if my lords may be pleased to issue notice, and just I'm pressing one prayer, which is prayer E, which is that to hold that the declaration of the result for the VH category should be subject to
So
the
let me
outcome of.
direct the who is happening for the commission is a party, West Bengal Central.
My lord, I
Commission
have
is a
already
party.
served
Yes.
upon them. my
Who
lord.
is happening for the commission?
For the state.
You are for the state.
Yeah.
So have you served upon
My
the
lord, I have
commission?
served
When
by-
you have served?
Yesterday,
When yes, that's why there is a
Monday I have
problem.
to leave from your
No,
lord.
but you should have clarified that this is the subject matter. Then this matter would not have been
I
included in the
apologize.
list.
my lord, it's on my,
Just that before the exam we had to be before my lord.
One
That's the
thing,
limited.
serve further notice upon the
my
commission.
lord. I shall.
Come back. I am directing the matter to appear on a subsequent date, and there, in presence of the commission,
My lord.
appropriate order is to be passed for exchanging affidavits.
My lord.
Yes. So if a short date may be given by my lords.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. West Bengal Central School Service Commission is not represented by learned advocate. Next paragraph. Matter relates to determination of number of vacancies reserved. And determination of number of vacancy earmarked for persons with differently abled persons with
Visually handicapped, if my lord may specifically
why
record.
visually handicapped should be separated, because it
Okay.
will come under the same heading. Persons
Very
with
well.
disabilities.
Very well. I am just representing them,
Visually
hence I was saying.
Visual impairment is one of the
Yes,
category
yes.
of
I follow.
person PWD category.
I
One of the
follow. I follow.
subcategory under PWD category.
Yes, yes,
So
absolutely.
it is to be considered in its entirety.
Fair enough. I follow.
Yes. কি বলছিলাম? Matter relates to কি বলছিলাম? Matter relates to determination of number of vacancies under persons with differently abled candidates. Now, for persons with differently able candidates, in connection with the selection process, which has been initiated based on recruitment notification. Where is the notification dated 30th May?
My lord.
That's P5, I believe. One second.
Page. Yes, Mr. Counselor.
My lord, page
Page.
number 353, my lord, in volume.
353.
Yes, my lord, in volume
Yes.
3, my lord.
Volume 3.
My lord.
Is that correct? Could you check 30th May notification?
কি বলছিলাম?
Hmm.
Notification dated 30th May 2025. Notification issued under memo number 1092/7016/CSSC/ESTT/2025 for filling up the post of assistant teachers in government aided secondary and higher secondary schools. Stop. Next paragraph. Learned advocate representing the petitioners submits that petitioners are visually impaired candidates. Visually impaired candidates.
Petition is an association of the visually
Oh,
impaired.
this is petitioners are
Association. Yes, Lordship. It's an association of such teachers.
কি বলছিলাম দেখো না learned advocate representing the petitioner submits that that petitioner association is constituted
Yes.
by visually impaired candidates. Stop. Members of petitioner association have applied in terms of aforesaid notification dated 30th May 2025 for participating in written test, which is scheduled on 7th September 2025. Stop. Next paragraph. Therefore, this court does not find that matter is required to be taken upon treating the same as urgent matter. So, next paragraph. Since West Bengal Central School Service Commission is not represented today, learned advocate for the petitioner is directed to serve another notice enclosing copy of this order upon Dr. Sutanu Patro, learned advocate, who usually represents commission. Next paragraph, list the matter for further consideration under the same heading on 16 September 2025.
I'm obliged. Thank you.
I apologize. Maybe I could not make myself, my lord, clear, my lord, while mentioning this matter, my lord.
Yes.
It was mistake on my part, my lord. I apologize.
Would my lord be pleased to record that the declaration of the result in this category shall be subject to the outcome of the litigation, or would my
No,
lord like to?
that is not required. Let the matter come up on the next date.
All right. I'm
Grateful,
obliged.
Lord.
Thank you. Thank you.
Item number 5.
For the petitioner.
আমাদের কোনো অসুবিধা নেই, লোক দেখলে আমরা চিঠি পাঠাই। 2016 রিক্রুটমেন্ট ক্যান্সেল হয়ে আরেকটা চলে গেছে। Number 6 and 7. Managing committee. That's number 6 and 7.
Yes, there is a report and affidavit of service.
Development. By the commission, my first time made the application to school did not forward. Then I forwarded to the commission. Commission.
What you have forwarded to commission?
The transfer. This is Tanushree Karmakar. Subsequent to division bench's order, I made a prescribed pro forma application to the school. School did not do anything for 15 days. Then I sent the application to the commission and the DI. Upon receiving that, commission has passed this order. School has not forwarded, but on my application, it has been issued.
বলেছে কমিশনের বক্তব্য কি?
It needs to be challenged.
It is not maintainable because all over 5 years, in case of medical, all over 5 years, as per the amendment. 16 my initial appointment. 2021, I obtained the task transfer. As per the
But
amendment,
once you have transferred in 2021,
the law says if it is on medical ground, all over 5 years used to be
but previously, whether your transfer was on medical ground,
general ground. Subsequently, I've got the BMO certificate also.
what is the ailment?
It is gynecological problem. I have annexed. I have
Your Lordship, I am for the representing the school.
Wait. It has specifically even stated that she requires to page 127, 120. And the minor the amendment says
I have passed also an order.
many orders that 5 years is not a part for all over. And it is a medical ground transfer. Can you see the amendment?
Where is that rule?
Yes. I have annexed my lord. It is at page 68, 70 of the petition. Kindly take the right hand side pagination. 70. Sub rule 1, rule 3.
It's an amendment.
It's an amendment.
of Rule 3.
Rule 3, which said 5 years. Now for medical ground.
Rule 3 of 2015 was amended.
Right.
Not readable. Do you have a better copy? Give me, I'll give it to you.
No, no, I mean my copy is. I mean folder গুলো দাও. May I read for you, Lordship? May I read? May I read? আমার ফোল্ডারটা দে, ফোল্ডারের ভেতর আছে সব। রেডি করে রাখো তোমার নিয়ে।
Yes.
Why they have not been given no objection, so that Jan has forwarded this to us. It's applied for that, there is only one flat. So when the commission is decided.
I'm representing the managing committee of the school, Your Lordship. There are 3,200 students, Your Lordship. There were, the post of 4 group D staff is vacant. There were 2 clerks initially, but out of this 2016 order, Your Lordship, the other clerk has been terminated. So there is only 1 clerk. That is the instruction.
Reason is work pressure. Original reason is
No, no,
work pressure.
serious gynecological problem.
I think so.
No, 127, 128.
You want to get rid of this work.
No, no, no. Kindly see 127, my lord. Kindly see 127. Page 1.
That's why you are taking shelter of amendment.
Serious medical problem, my lord. BMOH has found it. Let it.
Once in 2021 transfer.
My lord, she has lost her husband, based upon which, no, she got the appointment initially. Initially, she got on
compassionate ground.
Then, my lord, she had to take transfer. Now she is suffering badly from 2023. Page 128 is the medical report. 127.
In service.
Medical.
Yes, overall 5.
Overall.
Rule permits transfer. School will be in difficulty. If school if rule strength is robust, in that event school will be in difficulty. But if rule permits, what can be done? No?
Your Lordship, the school, as per my written instruction, the school has said that this school has got no objection in this. There is nothing standing in the way. The difficulty is there are 3,200 students. There is no clerk, no group. How the school will run? The instruction which have been sent to the DA have reflected that only. Because the post has to be, because out of the 2016 appointment, Your Lordship is aware, there was 1 group D staff, he has been terminated, the clerk has been terminated. So 3,200 students, 57.
Terminated? Who has been terminated?
Clerk, because of the 2016 appointment. So now there is no one, only 1 clerk is there, Your Lordship. Now how the school will run, that is the question put before the DI. As per my written instruction, the school says they have no objection to give NOC. But the school needs some people to run the show.
I am told there are 2 persons working in the school.
No, there were 2 persons, Your Lordship.
These are temporary arrangement that you cannot.
Yes,
What
yes.
can be done? A teacher, a lady clerk who has got appointment under on compassionate ground in a school where more than 3,000 students are there.
That fell for consideration before division bench also.
How school will run?
The honorable division bench has allowed me.
No, Mr. Lahiri, since you have been transferred in 2021, let the issue be decided on exchange of affidavits.
No, my lord. Kindly decide this, my lord. Kindly.
No, no.
Rejects my case. My lord, kindly rejects my case.
No, that is the pedagogy of the court.
Absolutely, absolutely.
Yes, you cannot dictate this
I am
court.
praying.
Yes, sorry. No.
Or my lord, kindly allow me to
Issue.
challenge that order separately. May I challenge that order? My lord, may I challenge the order of the petition separately?
Matter relates to matter has
Not
come
part
up
of
in
the
the list
petition.
under the heading to be mentioned. No, matter has come up in the list for the matter is heard in terms of the order dated 12th August 2025. When Where is your report, Mr. Chattopadhyay? Yes, yes. When a report is filed by the District Inspector of Schools, AC Murshidabad, dated 1st September 2025, and same is taken on record.
Kindly considers my predicament. I'm suffering medically, my lord. মেডিকেল আমার শরীর খারাপটা কিছু না, অসুস্থতাটা এখন গ্রুপ ডি, not even a teaching staff, non-teaching staff, my lord. Kindly allow.
নেই তো, 4টে গ্রুপ ডি রে, 2টো ক্লার্ক নেই।
You join the school.
Law permits me, my lord.
Look.
The 4th time litigation is being made, my lord. 4th round litigation.
How many students are there in the school?
Your Lordship, exactly it is 3,203. Your Lordship, this is the instruction the school has. 3203, Your Lordship.
3203.
Yes, Your Lordship. That's the instruction that was sent to me, Your Lordship.
And after transfer to the school, petitioner filed another writ petition.
That you not.
And matter went before the appellate court, but no order was passed. That was relating to a transfer on general transfer.
No, medical ground only.
Well, liberty was granted.
Liberty was granted by the division to make it prescribed pro forma.
But in proper format, Your
That
Lordship.
I made, and now it is on medical ground.
Your Lordship,
which has allowed me.
Your Lordship's own order is at page 19.
Order was passed by this court, passed an order
Yes,
Tanushree Karmakar,
Yes.
against which appeal was preferred.
Yes, Your
What is the order of the appellate court?
Yes.
Page 99 is Your Lordship's order, and Your Lordship, page 103 is the appellate court's order.
Division bench's order. There is a specific direction at the last paragraph of the division bench's order that it is to be considered.
Page 99 is the order of Your Lordship, and page 103 is the appellate court order.
Suffering badly.
সেটা তো বলছে 32 কিলোমিটার টু অ্যান্ড ফ্রো জানি, ও নিজে অ্যাডমিট করছে ও ট্রান্সফার অ্যাপ্লিকেশন। যাওয়া আসা মিলে 32 কিলোমিটার, এই তো 100 স্যার 117 পাতাটা একবার দেখুন, ও তো নিজেই লিখেছে। ওনার বাড়ি ডোমকল থানা, ওনার বাড়ি ডোমকল থানা, এটা হরিহর পাতানা, পাশাপাশি দুটো থানা। আমি তো নিজে মুর্শিদাবাদের ছেলে, আমাদের ওদেরকে শেখাবে। বহরমপুরে ফ্ল্যাট কিনে নিচ্ছে, সে যখন বহরমপুরে যাচ্ছে থাকবে, সেটা আমরা সবাই ঠিক আছে, সেটা সেটা তার পাশে দুটো পুলিশ স্টেশন, ও 32 কিলোমিটার লিখছে একটা মানুষ বলছি, বাট ও কোথাও একটা লিখেছে, আর একটা
In previous application, at the time of hearing, point of medical ground was also taken. Is recorded.
Page 127, 128, kindly takes once.
Kindly turns to 102, my lord, your lordship's observation.
Yes, I am reading my own order.
Yes, yes.
Makes application for transfer.
That is what was not in form, not periodically, once. Kindly take page 127 for once. Please, my lord, I request your lordship.
বলছি
We do not find any infirmity in the order of the single bench for dismissing the writ petition.
Absolutely. Kindly see the last paragraph.
Appeal and the connected application are disposed.
And the last paragraph, my lord, however, it is open to the petitioner appeal.
But you took this point medical ground in the first writ petition too.
Yes, yes.
Yes.
I took that.
So how this is maintainable?
No, the fresh liberty was given. Last paragraph. However,
Yes.
it is open to the petition appellant to make a fresh application for transfer in the prescribed form.
proper
And in
format.
such event, the authority will take a conscious decision as permissible. That
As
is-
permissible in law.
That was
But
allowed.
that the order of the my order was not interfered with.
Never
And
interfered.
and there you took the point that the application was also on medical ground.
All took 3 points together. That was not in prescribed
Lordship,
format. That was not treated in
the other
accordance with law. Now, in accordance with law, I made the application. My lord, now it is a fresh liberty was given to me. I made application.
Lordship,
And it is on going beyond the rules. It has been-
Domkol PS,
Lord,
and
kindly
the
take
school is in the next place,
127.
your lordship, Horiarpur.
Kindly take 127.
I'm native place is my Mushad, your lordship. Where is the Domkol? He's stating over there. The next place is Horiarpur.
34 I have medical grounds. Kindly
So
take
now it
127.
shouldn't be more than
No,
18
the
to
doctor
20
has said not to take journey. Doctor has said
First
not to
took
take.
transfer. After transfer, there was periodical applications for transfer.
Yes, it was not allowed.
On the ground of distance, then she found that it is better option to apply on medical grounds, taking the issue that petitioner is suffering from
Kindly
gynecological
take
disorder.
127 for once. For once. What is the
That's the
doctor is saying? Kindly see what doctor is saying.
2023 certificate.
127, 128.
Doctor will say differently if court calls that doctor.
That is a bit to your lordship. I cannot stand in the way. I will never do that. If your lordship, so I was tested. Let me be tested, my
We
lord.
had to deal with these doctors
Yes.
for a long period of time.
Yes, yes, I know, I know, I know.
So therefore, please don't say all these things.
On the based upon the records, I may be checked
Yes.
up by the medical CMOH or anywhere your lordship wants me to go.
And you have seen what kind of medical reports are coming
Yes,
before
yes, yes,
this
that I
court.
know.
In most of the reports are vague.
Vague report. Yeah, I understand that. My lord, I may be tested for that. Your lordship kindly directs a test, medical test of mine. I'm ready to appear in the medical test. Whatever documents I have, I can place before your lordship. If your lordship thinks it is not genuine, kindly send me for a medical checkup. It's found it can be because the division bench said conscious decision is to be taken. There is no decision at all.
আশেপাশে দুটো থানা, দমকল থানা, হরিয়ারপাড় থানা। কোনোদিন আবার 32 এখানে লিখেছে 109।
And now the new ground is taken, that is medical ground. I have stated in my order.
That is considering that division bench.
Once the petitioner has been transferred and joined the transferred post on 27 July 2022, at this stage, petitioner's offline application made on 9 requires no further consideration when portal is suspended. Had it been a case that after appointment of the petitioner on 23rd September 2016, first time petitioner is praying for transfer on medical ground, in that event, court could have exercised discretion, thereby directing the concerned state respondents to consider offline transfer application of the petitioner.
That was
It
considered.
is found that after being appointed under died in unless category, petitioner has been making applications for transfer periodically
Yes.
on different grounds that cannot be countenanced.
Yes. Considering that, division bench said that you make fresh application.
Your Lordship, the order
Take a
of the
conscious
division bench
decision.
is of 14th February 2025. And the medical cert is of 23.
আগেরটা দিয়ে করবো।
Learned advocates representing the respondents submit that petitioner was that petitioner was appointed as clerk in another school on 23rd September 2016 and applied for transfer and subsequently applied for transfer on the ground of distance. Stop. Said transfer application was allowed by the respondents. Consequently, petitioner was transferred to the present school on 27 July 2022. Stop. Thereafter, petitioner is trying to petitioner has been trying to get transferred on one ground or other. Stop. Next paragraph. School authority is represented by learned advocate who submits that roll strength of the present roll strength of the school is 3203. Yes. And if petitioner is transferred, there would be no clerk to serve the school. Stop. It is also submitted that apart from petitioner, there is no non-teaching staff in the school. Since who have lost job?
Your Lordship, one group D staff has lost job and one clerk.
Since one group D staff and one clerk have lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave to appeal within bracket C number 9586 of 2024 ki 25 dekhe nebe. Stop. Next paragraph. On perusal of records, it also appears that prayer of transfer of the petitioner was considered by this court in connection by this court while deciding the writ petition being WPA 27599 of 2024. Vide order dated 28 November 2024. And prayer of the petitioner for transfer was not allowed. So, order dated 28 November 2024 was appealed against, but the Honorable Division Bench, while disposing of the appeal being FMA 103 of 2025, did not interfere with the order passed by this court. And appellate's court order is at page 10. Appellates and the order of the Honorable Division Bench and the order of the Honorable Division Bench dated 14 February 2025 is at page 103. Next paragraph. Taking note, next paragraph. Though a fresh application has been made by the petitioner in prescribed pro forma, but taking note of the observations made by this court in the order dated 28 November 2024, in the writ petition being WPA 27599 of 2024, court finds it is a fit case to be decided on exchange of affidavits. Next paragraph, let affidavit in opposition to this writ petition be filed by 1 week after ensuing puja vacation. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Well, kindly
Your
take into
lordship,
record
the date.
a second. Kindly takes into record the commissions that I handed
No,
over.
that is not in the,
No, I'm
Your
handing over.
lordship,
That will be disclosed in the affidavit.
That is my
Your
submission.
lordship,
My lord,
the
kindly
date of
record my submission. I'll be in difficulty next.
your
My lord,
lordship,
kindly
only
record
one.
my
Next
submission.
matter, next
Your
matter.
lordship, only one
Reliance
submission.
upon
The date
this.
of joining should be 27/7.
That I have referred my order, previous order, where everything is
My lord,
recorded.
kindly records my submission. I
Next
handed
matter.
over. My lord, I handed over. Your lordship took into
Yes.
lordship took into consideration that document and lordship
matter.
is not
Item number 6.
Required at this stage.
Your lordship,
I'll be in difficulty.
item number 6, your lordship, Kamlesh Bhattacharya is appearing. He has some
Yes.
personal difficulty, so the praying for not as instructed by his clerk, your lordship.
May take back the document.
Only not this week, your lordship.
Hey, your document okay down now. Bar a copy of
My records, it will help me, my lord.
you are praying for time.
Yes.
Why?
As instructed, he has some personal difficulty, your lordship.
Milord, I am appearing on the behalf of the state, Milord. Last occasion, your lordship direct to file the affidavit. I report, Milord, and I duly দেখো না
Yes, where is your report?
Milord, that order I duly complied, Milord.
Where is your report?
Milord, that department still now do not send the report. In spite of the, I actually send that asking for the report, Milord. So kindly give me some time. So,
The order was passed on 13th August
yes, Milord,
2025.
I immediately next day I
So
communicate
let the
the
DI
order.
appear personally before this court. If
Kindly
DI
give-
is not adhering to your request and not taking steps, let the DI appears personally before this
Kindly
court.
one accommodation.
Your
Milord.
contention is this, that you communicated,
yes.
but DI is not cooperating.
Is
The court knows how to deal with this matter.
Milord, one accommodation, Milord.
Show me how you have
Yes.
forwarded.
Yes. To WhatsApp I forwarded DI.
Mr. Boisho, appear in this matter. There was a direction on 13th August
Milord,
2025,
kindly see.
but till date, no report by the DI. Yes.
Milord, kindly see that.
District School AC Purbo. Otherwise, court has to direct the DI to appear personally. AC Purbo Medinipur. Issue. When the matter is taken up for consideration, learned advocate representing the state respondents has prayed for accommodation to file report in terms of the order dated 13th August 2025. It is submitted by the learned advocate in spite of communication of this order to the respondent number 5. Report is not ready. Next paragraph. Since accommodation is paid for on behalf of the petitioner, since on the personal ground of the learned advocate, hearing of this matter stands adjourned. List the matter for further consideration under the same heading on 10th September or on 17th September 2025. Stop. Mr. Bhaskar Prasad Boisho, learned additional government period, is present in court, who is requested to appear on behalf of the state respondents. Stop. Learned government period is requested to regularize engagement of Mr. Boisho. Stop. Next paragraph. It is made clear if on the next date report is not filed by the respondent number 5 in terms of the order dated 13th August 2025, appropriate order shall be passed in order to ensure filing of report by the respondent number 5. Next.
Item number 7.
Yes, service issue. At the time of call, learned advocate representing the petitioner prays for accommodation to serve notice in terms of the order dated 13th. না কি বললাম দেখো তো, prays for accommodation, prays for further accommodation 13th August 2025. Next paragraph. Respondents are not represented today. Next paragraph. List the matter under the same head, under the heading motion in the monthly combined list of November 2025.
One thing, the school is under.
Sorry.
Arjo Samaj the Gurukul Trust.
Sorry, first sub notice, then I'll consider.
Item number 8.
Please write everything.
Yes.
Appointed staff.
When you have retired?
Retired, my lord, 31st December 2009.
2009. Why you are not getting 2009? Why you are not getting pension?
My lord, 2 months, 11 days, my lord, shortfall for my lord.
Yes.
10 years.
So why you are coming after such a long time, after 16 years?
My lord, I made application, my lord. It was issued, my lord, 2013.
Yes, what you are doing for more than 12 years?
There are I explain, my
It
lord.
was not known to the petitioner.
My lord,
He is a teacher. He doesn't know the.
my this staff, my lord, this staff. But I explain, my lord. There are 9.
What is the shortfall? Is there any representation to the secretary? Where is the representation?
My lord. And 24. Is 21. This 21.
Page 18.
21 para. Page 24.
DI will not consider it. This is Secretary, Education Department.
Exposure lordship, circular lordship, secretary either consider the matter to director of commissioner or director of education.
22, page 22, 22 is one of the representations.
That is when I come from the school.
Where is your representation?
And page
21, 20?
24.
Retired on 31st December 2009. This is less than 6 months. Less than 6 months already. There is a decision taken by this court. Division bench order is the Rabindranath Ghosh. Rabindranath Ghosh in case of organizing teacher. I was part of that division bench sitting with Justice Sen. Delivered judgment.
I know not I don't hear any objection.
Do you have this judgment, Rabindranath Ghosh? You have. So let me direct the Principal Secretary, School Education Department to take decision following ratio of Rabindranath Ghosh Supra.
And also 138, 138.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is wife of a retired and deceased Group D employee, Group D staff of a government-aided secondary school who superannuated on 31st December 2009. 31st December 2009. Stop. Husband of the petitioner was approved as an organizing Group D staff after the school was recognized in 2000 and retired on 31st December 2009. So, at the time of superannuation of husband of the petitioner, period of service fell short of requisite qualifying service of 10 years by 2 months 11 days. As a result whereof, as a result whereof, husband of the petitioner was not sanctioned pension. Stop. After death of husband of the petitioner on 1st October 2009, 1st October 2024, by presenting this writ petition, prayer is made for sanction of arrear pension as well as family pension on condoning shortfall in qualifying service, which is less than six months. Next paragraph. Respondents are represented by state respondents are represented by state respondents are represented by Mr. Bhaskar Prasad Boishu, learned additional government pleader, who submits issue needs to be decided by the concerned state authority if approach is made. Next paragraph. Similar issue was decided by the Honorable Division Bench on intracourt appeal being MAT 1917 of 2019 within brackets the state of West Bengal and state of West Bengal versus Rabindranath Ghosh. Stop. State authority is required to decide the claim of the petitioner for sanction of family pension based on in terms of ratio of Rabindranath Ghosh Supra. Next paragraph. Leave is granted to the petitioner to make a representation to the secretary's party, to the Secretary School Education Department. Yes. To the Principal Secretary School Education Department, being response number 1, by fortnight from date. Stop. If representation is made within the aforesaid time, response number 1 is directed to decide the claim of the petitioner seeking sanction of pension, condoning shortfall in qualifying service of the husband of the petitioner within a period of 8 weeks thereafter, on granting opportunity of hearing to the petitioner or her representative. Stop. Reasoned decision shall be taken by the respondent number 1 and same shall be communicated to the petitioner. Stop. At the time of taking decision, the respondent number 1 shall follow the ratio of Rabindranath Ghosh Supra. Next paragraph. Writ petition stands disposed of. Next.
Item number 9.
Yes.
Petitioner will the husband of petitioner will the headmaster of the particular the secondary school. Is retired from the service the year 2007. Subsequently, the after the petitioner husband was found ADR salary was dues, but that has not been released.
Husband of the petitioner was a
Yes,
teacher.
Yes.
He retired on 31st December.
Retired on 31st December 2007.
Yes.
And the one memo has been issued by the DI to the Commissioner of School Education, page 13. The petitioner area salary should be considered immediately. One of this memo has been issued by the District Inspector of School, Birbhum, to the.
Now the wife has come claiming
The
salary of
salary which is pending before the authority, my lord.
by area accrued.
This is the memo has been issued. This husband area salary is admitted by the DIF school.
Husband died on 31st December, 31st October
2019. After that, subsequently thereafter the
so you are claiming area from January 1988 to 28 February 2007.
The DI has been issued the memo on 3rd April 2024 to the school authority to resubmit of the claim of the petitioner.
Where is that memo?
Kindly see page 16.
Page 16.
Yes. But this memo has been issued by the DI school, Birbhum, to the head of the institute of the Daspalsa High School, my lord.
Who is appearing for the school authority?
I have served, my lord, the school also received the copy.
Because it is stated, it may be noted that if the above mentioned area is already paid, ignore it and report to the
My
undersigned.
lord, subsequently thereafter, my lord, hearing was conducted before the
He will
DI.
hear you.
Hearing was conducted before the DI. My lord, kindly see his native.
What is your instruction?
Instruction from DI, my lord. My lord, the DI's instructions when the school authority is not submitting
Yes.
petition or husband, death certificate and other required documents, my lord. The
No,
school-
but why this area accrued?
My lord, sir, the DI is just
Because
He sees
because
that
the husband of the petitioner was the headmaster who retired on 31st December 2007. Now DI is issuing a memo on 3rd April 2024 addressed to the present headmaster for processing the claim of arrear claim. So why arrear accrued?
My lord,
And which was which is remaining outstanding as on date when the teacher headmaster retired far back on 31st December 2007.
My lord, that period I have to take again, my lord. I have-
Why matter was hard previously, so
subsequently,
far I remember.
another memo issue, my lord, kindly see page 21.
My lord, DI has just admitted.
Hearing was held before the chamber of the DI, my lord.
Because it is your memo dated 3rd April 2024. So DI has to file a report issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner being wife of
Report file for
deceased
report.
headmaster who retired far back on 31st December 2007 has claimed comma has claimed arrear dues from 1st January 1988 to 28 February 2007. Stop. Based on such claim, District Inspector of Schools AC Birbhum being respondent number 4 issued one memo on 3rd April 2024 addressed to the present headmaster of Dashpara High School Birbhum for submission of requisite documents in order to process the claim of the petitioner seeking release of arrear dues. Stop. Next paragraph. Respondent number 4 is directed to file a report disclosing how arrear accrued and why till date it has not been paid. Taking note of the fact that husband of the petitioner retired from the post of headmaster on 31st December 2007 and the arrear claim relates to the period from 1st January 1988 to 28 February 2007. Next paragraph. Let such report be filed by 2 weeks from date. List the matter under the same heading for further consideration on September 2025. Next.
Item number 10.
10, well, I am up for the
I am for second.
petitioner. Well, the petitioner is the untainted teacher. Well, they have challenged the selection process. Well, the notification issued by the school service commissioner. Well, this is
why
blood.
We have filed a petition here. Just challenging the rules and etc. Everything. Against the judgment of Urunima Pal, they filed SLP. And in that SLP, they have taken all these points. And my lord, kindly state this one.
Well, I have been ordered, my lord, they were lordship ordered. Subsequently, my lord, they have challenged SLP before the court. My lord, this is annexing the writ petition,
Sir, I
similar
do not
order.
mind. Either
My lord,
they
learned,
will
my lord,
not
senior
take
friend
SLP,
also.
let them proceed here, Or let them do not say.
No, no,
let
this
them proceed
SLP
with it.
admitted by the
Then
Supreme Court,
in
my
that
lord,
case,
this
how
is the
can
order
staying
passed, my lord,
prayer
the-
here?
This is the pending, my lord, I have annexed everything, my lord, before the Supreme Court.
Yes. এটা
কি লোক
অভিজিৎ সদগন, হ্যাঁ, then
তিন পার্টিস করতে পারেন
এটা
Yes, that is.
Yes,
and
my lord,
yes, and
I
all
have,
they have got their admit
I have-
cards. All they
my
have
lord,
Already granted the benefit of relaxation
no, no, my
to the
lord,
extent of
my
50%.
lord, kindly allow me to, my lord, this.
So
my
why
lord,
this
45%.
I,
45%, 50% to 45%.
yes, my lord, this writ petition is pending before lordship. Subsequently, your lordship passed the similar order.
Same
and-
petitioners filed this.
No, no, this
Same,
is challenging, my lord. This is writ petition annexed before the Honorable Supreme
Maybe.
Court. My learned senior point out that at the time of hearing, this writ petition is pending before the Honorable High Court.
Where is
Apart
happening?
from,
Where I have
apart,
pointed out, where
well,
it is
I
there?
have, my lord, this annexed the writ petition before the Supreme Court. This writ petition is pending, but subsequently division bench
No,
and
these have
single
not been
bench
said to
order.
Supreme Court.
My lord,
Supreme Court said
well,
that
I agree with
untainted
the
and
SLP,
the
but
normal
Since
order.
the Supreme Court is in session of the matter, today how this court,
11th is fixed for the hearing.
yes,
my lord.
how this court will consider it.
No, no,
today.
kindly fix the matter after that, my lord.
Why? Let me dispose of the matter
No, no, my
into
lord,
a
one
pendency.
second, my lord. Subject to lordship
Well, all
correction.
points
Well,
which
I
are
have
there,
stated the writ petition
all
is
that
pending.
points
All
are
these
in the
points are an
SLP.
issue before
And
the
leave has been granted to file SLP.
SLP
Can you see?
Yes, yes, I
Yes, leave has been granted.
granted
Since
for
they
the
have not.
writ petition
Yes.
pending. Well, I bring with the, my lord, SLP copy.
No, since you have preferred an SLP and SLP is admitted and the matter is pending before the Supreme Court,
That
what is
is
the reason
but-
for filing a subsequent writ petition?
My lord, that is the point before the Supreme Court. The writ petition is pending and order passed by the honorable.
That was not the
That's
point.
why SLP
No,
point.
no.
Well, I bring
What is the
the
point before the Supreme Court?
writ petition is pending. Subsequently, my lord, your lordship was passed the similar order and division bench also hold that order and that order challenged before the Supreme Court. That's why during the pendings of the writ petition, I annexed the writ petition in the SLP. This writ petition pending before the honorable High Court also. my lord. After that, my SLP admitted.
No, the Supreme Court has not heard all this. No, 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 no.
Well, I
You
have
didn't
annexed
say
the
this.
order.
What has happened, Miller? This is all that matters.
Well,
No, please.
learned senior
All that.
present
No, no,
here.
no, 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 no. I was not. Don't say all this. Don't say all this. Don't that. Don't make. Millard, what has happened? What has happened? All that SLP bunches are coming and they are saying they are the untainted teachers. We are saying yes, these are the untainted teachers. We have given them admit cards.
I failed to understand without going into the niceties that once you have filed an SLP, which is an order was passed on 25th August 2025, and matter will come up further procedure will be postponed accordingly. So this is the order passed that as it was passed in other matter.
Yes.
Now, why you subsequently have filed the present petition? Because this was filed on
prior to that.
No, no.
I have.
Yes,
21st July it was filed.
21st July, after the judgment, the delivery of the judgment of the division bench. After your lordship had passed the I hope it was anyway 7 July, 14 July, anyway 7 July, 14 July division bench, 21st July Supreme Court. First matter is the 21st July, which has been dismissed, and this has been filed on 21st July.
The order of this,
But I do not mind. Let him give an undertaking. He will not proceed with the SLP.
No, that is.
No, you can't have,
No.
Milord, it
Malad,
cannot
I
have
will bring.
same
Malad,
prayer in.
If I would take any wrong in the SLP, then I will give in the undertaking. But because I have stated in the.
Milord, it is hit by
SLP,
doctrine of res
So
judicata.
in the SLP 16 July 2025, Arunima Pal is challenged.
Arunima Pal has challenged.
And
Mat
I have
1024.
10?
Mat 1024 is
Arising out of that.
yes. So division bench order was challenged by the petitioners.
By the petitioner also.
petition
Milord,
pending.
there are,
Why separate?
may I just
petition
tell you lots what has happened? Two types of one, that Arunima Pal was an unsuccessful candidate. All their SLPs were dismissed. So but the untainted teachers, they are not covered by Arunima Pal, but all their points have been covered. Supreme Court has said all right.
Relaxation has been granted
Relaxation
to the extent of 45%.
if anybody is there, but not a single case is 45%. Relaxation was required, 50% all they have there. Now that has been given. Now the same challenge, the rules, which was your lordships, I have already pointed out to the court, these points have been covered because of the Arunima Pals you have dismissed. The court is saying, all right, we have issued the notice, on the next day we will see to that. Anyway, now the point here is, OBE Sadhu Khan has filed an SLP special petition against the Arunima main judgment, your lordship's judgment, and then they marched with the division bench judgment. Against that judgment, entire rules have been challenged. Here is also entire rules have been challenged. Therefore, this naturally this petition is not maintainable. If it is maintainable, I don't mind. Then in that case, your lordships follow your lordship's judgment.
In that case, after pending.
I don't mind. Kindly take it, and I will rely upon your lordship's judgment.
Sanjay Doli,
Sanjay Doli, na? Yes, Sanjay Doli. Follow that, Milord. That
I have
accepting untainted part, your lordships kindly follow that judgment.
Taken the averment, the writ petition is pending. That's why I come before your Supreme Court, because this same issue, the order has been passed by the honorable single judge. I have not stated the writ petition not pending and separate issue. In connection of this writ petition, I filed the SLP. I have also annexed in the SLP. This is the writ petition, this is pending before the honorable single bench. So after that, the SLP, the admit. And not fixed on the 11th September, the matter is fixed. Kindly take it up 12.
Why both the proceedings on the same issue?
Because
one judgment, just I rely on this.
Submitted before the Supreme Court that you filed the writ petition.
Yes.
That's why you filed a writ petition.
Yes,
before
I have
the court,
stated no annex.
therefore you are not pressing this SLP. That was not your case.
Yes. After writ petition, pending the writ petition, thereafter SLP has been filed.
Yes.
You have stated in
So
the
you could have withdrawn the SLP from the Honorable Supreme Court in view of pendency of this writ petition.
Well,
But
I have
you did not
stated in
do.
the issue, apart from that, SLP to be admitted by the Supreme Court.
So if SLP is admitted, let it be decided how this writ petition is
In this connection, I have filed a SLP.
No, you have filed
If your
SLP
lordship-
against Arunima Pal.
No, I have
that-
annexed in writ petition.
Your SLP
SLP
is against the order dated 16 July 2025, passed in MAT 1024.
Yes.
Passed in MAT 1024. Mr. Bandyopadhyay, MAT number is not telling.
No, bat number, Arunima, he challenged the judgment of Sanjay
Date is
Kumar
same.
Dolui. Sanjay Kumar Dolui, and there are different mat number was there. Subject matter is same. Sanjay Dolui decided in terms of Arunima Pal. Arunima Pal. In that case,
Arunima Pal was decided in terms of Sanjay Dole.
correct. But Arunima Pal appeal was taken up first.
Yes.
Arunima Pal appeal was taken up. Joseph,
That order is dated
Division
21st
bench
July
judgment is-
21st July 2025. Arunima Pal appeal before the Supreme Court.
Yes.
Division
Division bench
Arunima
judgment.
bench I have.
Yes. Arunima Pal SLP was dismissed. Then all waiting list candidates, etc., those who are not successful, all their SLPs were dismissed. Correct. Second part is coming right from Vivek Parua. Vivek Parua is an untainted teacher, and he was saying that he didn't get the admit card because of that. We have said so.
Teachers are not untainted teachers.
No.
Yes.
Yeah, they are untainted. They are untainted. They have got the admit card. They have
Got the relaxation.
No, no.
Well, relaxation was not required in their case. Yes, not required. Admit card was given and not required. Now, in the appeal, is SLP itself, they have challenged that Arunima Pal, Sanjay Dole, whatever the cases. In his case, the SLP kindly similar that he has challenged. SLP copy ache? Mal kindly excuse me, Malad. I am giving from the iPad. Kindly excuse me. This is SLP page now.
At present, no SLP copy.
Yes, it is with
tomorrow I'll bring the hard copy of the
It is
SLP.
with me. Sanjay Kumar. Scroll down, Milord. They kindly see Sanjay Kumar Doli, page 1. And then Milord see, then page, can see the issues involved in this appeal. Then they have annexed the Arunima Pal. This is the impugned judgment before the Supreme Court. This I am saying impugned judgment of the Supreme Court. Now, Milord, kindly see the judgment. Then your loss got it.
Yes.
Hello, got it. Now, Milord, kindly come. Just I will show to you. See, forget about this judgment. Now, kindly come to points. Point of law. And kindly see now. Kindly come to page 30.
1-3.
30 fast. 30. Why I am showing the cause title. See, Obijit Sadhukan, not a party, petitioner number 1. Not a party means in the Calcutta High Court, they were not party.
Yes, Obijit Sadhuka, point number 1.
No, not a party, all they are not a party. Then kindly come to my lord, page. Page kindly see. Kindly come to page 44. Then 45, question of law.
44.
Yes. 45.
Yes, question of law.
Whether the Honorable Division of the Honorable High Court have failed to consider the incompetency of the Honorable High Court's order dated 27 as the response of the published notifications, but the person notification dated so and so is completely different from the 2016 file written, and the several points have been newly included so and so. Whether Honorable Division of the Honorable have failed to consider the school service commission have published notifications so and so. Entire process is being carried out so and so, so and so. Same question. Whether the Honorable Division of the Honorable High Court failed to appreciate that the contents of the notification Rule 2020 in itself are contrary to uncertainty and also against the well-settled principles that the process of selection cannot be changed in the midway, so and so. Then kindly see next point, whether the Honorable Division of the Honorable High Court have failed to consider that in the new notification the committee reserve the rights to cancel with so and so, so and so. Then whether the Honorable High Court have failed to consider the entire recruitment has been changed and the rules of second selection is completely changed. The response authority is totally contrary to the observation. Whether the Honorable Division of the Calcutta have failed to consider the academic marks of the written test as well as the interview, as well as professional test has totally changed. Old marks, so and so, so and so, so and so, so and so. Whether the Honorable Division Bench of the Honorable have failed to consider in the previous notice, there was a clarification that one candidate may apply in the post of so and so school by giving marks. Whether the Honorable Division of the other kindly see, entire rule has been changed. Challenge. And let them say, I will be happy. Let them say, let them say, all they are urging, if the selected candidate, they teaching experience don't want, we will delete it.
No, that is not the
Supreme Court has said to them, you see, the rules have made in such a way that all candidates should be appeared, and you have given 10 marks extra
for past experience.
Past experience. Very honestly, to accommodate them. If they don't want, we will delete it. We'll delete it.
So
let them agree.
You are permitted to participate. Admit card issued. Now you are challenging the 2025 rules. That rule, the validity of this rule is one of the issues before the Supreme Court in connection with the SLP, where an judgment was passed in your SLP. So how this present petition is maintainable?
Present petition prior to the file, before filing.
One judgment just I showed to your lordship. Just one. 2007 6 SCC 120. That's 18. Paragraph 18. I am giving to your lordship. Court content. The court would not ordinarily permit a party to pursue two parallel remedies in respect of the same subject matter. But where one proceeding has been terminated without determination of the list,
SCC,
6
SCC,
120.
120 Joseph के paragraph টা বার করে দিয়ে দে paragraph 12 Joseph কে দিয়ে
This is not placed before the Supreme Court at the time of hearing. My learned senior friend was one of the senior
no
present there. Well, I have stated my writ petition is pending. That time oppose. Thereafter, my lord, the
No,
SLP was
oppose.
allowed. But because my lord, I have not suppressed anything. Well, I have stated my lord, similar issues. The division bench also hold that my lord, the selection process is legal. That's why my lord, I filed the SLP before challenging that order. And I have annexed this writ petition before the SLP. SLP
Yes, paragraph
18 my lord.
Where is the notification? 29th May, 30th May 2025.
Just giving.
Page 160. 29th May, page 146, 30th.
146.
29th May, 30th May, 150.
Notification is 30th May 160.
Only one thing that they are now annoying everyone. Supreme Court is also saying, what are you are doing? Point is open. Already one writ petition has been dismissed. Article 32. We have entertained the petition. Why multiplicity of these proceedings? So many proceedings.
30th May.
160.
No, petitioners were parties before this court in Sanjay Daloi and
No. They were not parties. That is the reason not a party. They directly filed the special leave petition with the leave.
during the pendency of the writ.
That's why this writ petition.
Yes.
That's why this writ petition is filed subsequently on 21st July.
21st July.
After that, SLP file, my lord. Because due to pendency of this writ petition.
And last occasion on that day, time was taken.
I have
And in fact, your lordships kindly see, 25th August, the matter was before your lordships also, and 25th August, the Supreme Court, the matter was also.
Same day.
And that day, time was taken by them from your lordships. Huh? Order, right?
Order record.
Just
simple
No, one thing, my lord, kindly issue raised before the Supreme Court. This after issuing this point of which is pending before your lords. Thereafter, SLP is admitted. That would be more considered because the
Yes, the Supreme Court will decide the issue. How parallel proceedings are maintained.
This is not the parallel. In connection of this, petition has been filed. SLP has been filed. But during the pendency of
But the challenge is this 29th May 2025 and 30th of May.
This has been decided by our lords in another matter.
Yes, so
that
either I have to follow my own judgment, which has not been interfered with by the subsequently by the division bench of the Supreme Court, and otherwise it has to be decided that this petition is not maintained.
I have not filed that trace SLP. I have filed connection of this petition.
In the writ petition. The West Bengal School Service Commission within bracket selection for appointment to the post of assistant teachers for upper primary level of classes within bracket except work education and physical education close bracket, comma, classes 9 and 10 and classes 11 and 12 close bracket rules 2025, and recruitment notification dated 30th May 2025 issued by the West Bengal Central School Service Commission under memo number 1096/7016/CSSC/ESTT/2025 are questioned. Stop. Petitioners are untainted selected candidates of first state level selection test 2016. 9, 10, 11, 12.
Yes, madam.
2016 for 2016 within bracket classes 9, 10, 11 and 11 and 12. Stop. Next paragraph. Issue involved in this writ petition was decided by this court
বলে দিলে হবে না তোকে জানাবো তোমার আগে তোকে জানাবো
on a batch of writ petitions, first one being WP8 12505 of 2025 within bracket Sanjoy Kumar Doloi and another versus the state of West Bengal and others. Vide judgment dated 7 July 2025. Stop. The judgment stop. The judge stop. Judgment delivered in Sanjoy Doloi Supra was affirmed by the Honorable Division Bench. Vide judgment dated 16 July 2025, passed on intercourt appeal being MAT 1017 of 2025 within bracket Orunima Pal and others versus the state of West Bengal and others, and judgment dated 16 July 2025 was carried in appeal before the Honorable Supreme Court, and special leave to appeal within bracket C close bracket number 19222 19222/2025 within bracket Orunima Pal versus state of West Bengal and others was dismissed. Video order dated 21st July 2025. Next slide. Where is that Obijit Padia where this relaxation of 45% was granted? Vivek Padia. Vivek Padia.
1 second.
I'm giving.
Yes, I have.
Lordship, yesterday it was with your Lordship.
Next slide.
এটা পরেরটা, প্রথমেরটা।
Where is the first order in Vivek
First order,
Paria?
এটা বিবেক পারিয়া, এটা second order.
I have the order dated 29th.
Nice, it is second order. That's
This is second order.
বিবেক পারিয়া first order টা দাও। মানে I am giving.
আমি সুপ্রিম কোর্ট
দাদা, এটা তো কালকে।
সুপ্রিম কোর্ট থেকে বার
Just I am giving. বিবেক পারিয়াটা দেখ।
4605
এটা second order.
আমি বার করছি। ও বেরোবে না এসএলপি বেরোবে না।
ওইটা কোনটা? ওইটা ফার্স্ট অর্ডারটা। Yes, madam. This one, madam. This one.
Yes.
This one.
Next paragraph. It needs to be recorded herein that the Honorable Division Bench passed an order on 21st August 2025 on an on special leave petition within bracket civil close bracket diary number 46049/2025 within bracket Vivek Paria and others versus State of West Bengal and others. Granting relaxation to the extent of 45%.
Without insisting upon the compliance, let's cut. That
Granting relaxation, observing granting relaxation, observing that without insisting upon their complying with the newly introduced eligibility criteria
of
securing 50% minimum marks in graduation and post-graduation, comma. Under the West Bengal School Service Commission within bracket selection for appointment to the posts of assistant teachers for upper primary level of classes, close bracket, within bracket except work education, physical education, close bracket, comma. Classes 9, 10 and classes 11 and 12, close bracket rules, comma 2025. Selected and appointed untainted candidates who were permitted to continue their service till 31st December 2024 at 31st December 2025, comma, shall be allowed to participate in the fresh selection process. Stop. Next paragraph. Petitioners in the present writ petition, as it is submitted by the learned advocates representing the parties, are untainted and selected candidates who are permitted to continue service till 31st December 2025 and got the benefit of the order of the Honorable Supreme Court dated 21st August 2025, passed in Vivek Paria Supra. Stop. It is also submitted that petitioners have received admit cards and they would be permitted to participate in the examination scheduled on 7th. Examinations on scheduled dates. Next paragraph. Mr. Kullan Bandyopadhyay, learned senior advocate representing West Bengal Central School Service Commission, has opposed this writ petition. Due to pendency of special leave petition within bracket civil close bracket, diary number 41453 of 2025, within bracket, Obijit Sadhukan and others versus State of West Bengal and others, which was preferred, questioning judgment and order dated 16 July 2025, passed in Orunima Pal, Supra. Stop. It is also brought to the notice of this. Stop. Order passed dated 25th August 2025 on SLP on special leave petition civil diary number 41453/2025 is placed before this court and same is taken on record. Stop. On perusal of the said order dated 25th August 2025, it further appears that Supreme Court is in session of the matter where similar issue is involved. Stop. Next paragraph. Therefore, this court finds no reason to entertain this writ petition at this stage. Please open this judgment. Paragraph 16. 18. Next paragraph. In this regard, reliance is placed on the judgment reported in 2007 6 SCC 120 within bracket Orunima Barua versus Union of India and others. Stop. In paragraph 18 of Orunima Barua Supra, it has been observed by the it was observed that a court would not ordinarily permit a party to pursue two parallel remedies in respect of the same subject matter. Stop. Next paragraph. In aforesaid conspectus and taking note of the fact that special leave petition within bracket civil close bracket diary number 41453/2025 is pending before the Honorable Supreme Court. Present writ petition stands dismissed. Urgent Xerox certificate copy.
That first order also, your losses keep it in your file. Vivek Pariyar
Yes,
first
yes,
order. Deeply obliged.
Yes, fine. Affidavit of service filed on behalf of the petitioners is taken on record.
Item number 11.
Well, I'm for the petition.
I'm for the commission.
I'm for the state response. Kindly come to page 82 for once.
Yes.
Been withheld on the ground of single subject teacher.
Distance ground.
General.
Single teacher.
Single teacher. 3rd January notification there.
Let third steps be taken following third notification, government notification dated 3rd January 2020.
He has made a subsequent application also. That is pending before this.
Application for
Transfer application in the portal.
Yes, last application. Portal was
6th
not pending.
September 2021, last application.
No.
Yes, yes.
No.
Page 82.
15th July, the first serial number. That is pending due to suspension of portal.
Subsequently, last application is 15 July.
My lord, that is pending.
Pending, but on the same result, same fate.
Applicant to HY. The head of the institution will forward it to the DI.
Yeah, yes.
Not 6 September, but,
Yes.
but still the
subject
staff
teacher
pattern is same,
same,
that you are
same.
the single teacher.
I'm single teacher.
Third application.
Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next slide. Petitioner applied for transfer on general ground within bracket distance on 15 date on 15 July 2022 on Utsotsi portal or on portal, and the grievance of the petitioner is transfer application is yet to be processed and decided by the concerned respondent authorities. Next paragraph. Respondents are represented by learned advocates who have submitted that petitioner is single teacher in the subject in higher secondary section of the school. Stop. It is all. It is. Stop. Stop. Since petitioner is single teacher in the subject, government notification dated 3rd January 2022 is required to be followed by the respondent authorities. Next paragraph. In view of the respective submissions made on behalf of the parties, have you served upon the school?
Yes, my lord.
Complete.
Delivered হয়েছে তো?
Head of the institution of Maula Netaji Vidyalaya within bracket HS, Howrah, being respondent number 6, is directed to forward transfer application of the petitioner to the District Inspector of Schools, AC Howrah, being respondent number 5, by fortnight from the date of communication of this order. Stop. On receipt of transfer application, respondent number 5 is directed to make an endeavor to find out a teacher from neighboring school who can man the post of the petitioner if petitioner is transferred, or who can man na kore, who can be deputed in place of petitioner, who can be deputed in place of petitioner, thereby facilitating transfer, thereby facilitating petitioner's transfer in terms of said government notification dated 3rd January 2022. Stop. Next paragraph. In the event a teacher is found from neighboring school to be deputed in place of petitioner, comma, petitioner shall be transferred immediately thereafter. Next paragraph. Writ petition stands disposed of urgent.
Grateful to your lordship, much obliged.
আচ্ছা উপরে এফিডেভিট অফ সার্ভিস ফাইল
Item number 12.
But as for the state. Last occasion service effective, but total envelope missing. So my lord, I have completed.
Third. Yes.
My lord, case is, my lord, petitioner is a job loser in respect of first SLST selection process. Parallelly, petitioner participated in upper primary selection process in work education and physical education. My lord, petitioners, both the petitioner, two petitioners, both the petitioners are, my lord, are waitlisted candidate in respect of, my lord, work education subject.
Panel expired long back.
No, my lord, petitioner.
2020 panel expired.
Supernumerary similar issue is pending in this, my lord, today's item, your lordship's courts. Similar issue called for a report. Both are, my lord, supernumerary post has been created 2022. Both have been called for, my lord, both have been called for the counseling. But since the petitioners are working in that selection in 9-10 level, petitioner could not appear. But subject to correction, my learned friend, my supernumerary post has been created only to facilitate for the waitlisted candidate in respect of the work education and physical education. Petitioner duly, my lord, communicated by the notice that appeared in the particular date for counseling.
What order I have passed?
Yes, yes. My lord, the report is called for. My lord, similar issue is pending to the item number 196. My lord, let it be hard together, my lord, since the
কোন ম্যাটার হ্যান্ড আপ করলি?
motion মন্ডল। So far, supernumerary post is concerned, this is not over, but it is pending because of our results.
You have deposited the court fee.
Yes, yes. My lord, if your lordship turn page number 28, my lord, petitioner has been called for 10th November.
You are a waitlisted candidate.
Yes, yes. Waitlisted candidate called for the counseling supernumerary post in respect of supernumerary post, which has been created 2022. Page 28, my lord. My lord, page 28.
Viral, I am placing this matter in the combined monthly list of.
My lord, a similar matter, my lord, actually dismissed after.
That is previous.
Supernumerary post.
No, this same matter, that this matter was also cited on that
on the same day, and the reference was made to the fact that it was in the list. Matter is in the list. Supernumerary posts have been made for specific candidates. Candidates cannot just walk in and ask for them.
My lord, I have been called for interview, counseling in respect of supernumerary post.
তাহলে কি চাইছিস?
আমি জানি I have not participated. I want to.
চল। কোনো 22-এর রিসিট দেখাচ্ছে। So this matter is slightly different. Paragraph 5.
Decided my instruction. That's not decided.
Not waitlisted candidate.
Your lordship, that order I know, but your lordship.
Petitioner is not waitlisted candidate. Here petitioners are.
Yes, yes, and was called but was absent.
So I am placing this matter in the monthly combined list of
That-
November.
November.
Let me see what decision can be taken in the another matter
Yes, yes.
where Dr. Patro has
And
been
liberty
directed to
given to the
obtain
minister.
instructions and
Yes.
instruction.
My lord, liberty may
And
be
if
given to.
ultimately an order is passed, that will
Lordship.
govern this matter.
Yes, my lord, liberty will be given to mention the. My lord.
Yes, yes, that
Not-
it is different. It's not a
Yes,
waitlisted
yes,
candidate.
yes.
Supernumerary post is for waitlisted candidate. You specifically submitted in when I heard this matter on 23rd June.
Yes. This was a regular candidate, but did not.
Then you prayed for time to obtain instruction.
Yes, yes.
My lord, page 20, 29
issue.
is the relevant document which I have been.
Affidavit of service filed. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Next paragraph. Land advocates representing the petitioner and West Bengal Central School Service Commission have jointly submitted on similar issue. Another writ petition is pending for another issue is pending for consideration, being WPA 11767 of 2025 within bracket Mousumi Mondol versus the state of West Bengal others. Next paragraph. Hence, list the matter. List this writ petition under the heading motion in the monthly combined list of November 2025. Stop.
Item number 30.
13, I am for the petitioner, my lord.
I am appealing for the school authority.
Yes.
My lord, DI is the answering respondent over here, my lord.
Place your case.
My lord, I'm praying for a higher scale of pay, which I'm been since my lord has only passed judgment where I don't want means prior permission is not needed. My lord, I have passed graduation in 2009 and I have joined the post graduation is also in 2009. But my lord, I got recommendation and for the school in 2011. Even board has given me sanction leave. But DI is not considering my application for.
But you have completed the higher course of study after obtaining prior permission from DI.
Yes, my lord. I have
You
completed.
obtained prior permission from DI.
Yes, my lord. Even school.
Prior to enrolling yourself with the university.
Yes, my lord. I was ready.
Where is the prior permission?
My lord, kindly come to page 28. My lord, here board has given sanction.
Not board. Where is the prior permission by the DI, which is required in terms of 27 November 2007?
My lord, no, that I haven't.
Whether any decision is taken by the district institute of schools.
My lord, yes, school has given all the
Whether any decision is taken by the district inspector of schools
no, my
on
lord.
your claim of claim
Yes,
for
my
higher
lord,
scale of pay,
they have given objections regarding that. No decision has been taken yet.
where is your representation?
My lord, representation is there for in page in 39, my lord. My lord, kindly come to
Page 39.
Yes, my lord.
Is secretary to the school.
My lord, I've given that even.
It's a delegating school.
No, my lord.
Well, I have a report, my lord.
What does it say?
He's not entitled, my lord.
Why?
Why, my lord? I just
Tell me, this is for you. Tell me what is stated in the report. You read the report.
In terms of the my lord, provision, my lord, 1 and 2, 1 and 3 of the dated my lord 27 November 2007, my lord.
That is prior permission.
Neither the petitioner nor the petitioner, my lord, neither the petitioner nor the
That is
school of-
prior permission, 27 November. That is what court is asking her. Where is the prior permission? Anything new is stated in your report?
No.
My lord, even prior permission
But
is not.
the representation which you are relying upon at page 39, it is addressed to the school. Where is the representation to the district inspector of schools?
My lord, that school has given for the.
You should have made a representation. Where is your approval memo?
My lord,
Approval of appointment?
approval of appointment. My lord, it is in the page 23. 24, sorry, my lord.
No, by the school DI.
Recommendation was given, my lord, by the board.
Where is your approval of appointment?
My lord, recommendation was given by commission on page 23, my lord.
Where is your approval of appointment?
I have an annex that one, my lord.
In higher scale of pay, you are not. You have not annexed approval of memo.
No, my lord, that I have an annex, my lord.
File a supplementary affidavit.
If my lord kindly see, there I have annexed the DI approval, my lord. And my lord, when I got the appointment at that time, I was pursuing for the MCA, that is the post-graduation examination. After and even lordship judgment is there that prior permission is not required. My lord, kindly come to. My lord, kindly come to page. The last
Date when the post was retained.
My lord.
It is a date when post was retained after 2 years.
Yes.
Initially, you were appointed for a period of 2 years. Subsequently, this retention memo was issued. That's why come to the third column at page 55. Date from which the post is retained permanent with effect from 18 July, probably 2011. Prior to that, when you were appointed.
Yes, my lord. But my lord.
Issue. Petitioner has affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner has claimed higher scale of pay or postgraduate scale of. Petitioner has claimed postgraduate scale of pay for acquiring qualification, for acquiring higher qualification in the relevant subject of teaching. Stop. However, on perusal of the writ petition, it appears approval of appointment accorded by the concerned district inspector of schools AC Kolkata is not enclosed. Next paragraph.
It is enclosed if I'm
Leave is granted to the client advocate for the petitioner to file a supplementary affidavit in order to bring on record approval of appointment issued in favor of the petitioner. Next paragraph. Let such supplementary affidavit be filed by 10 days from date. Stop. List the matter under the same heading for further consideration on 17 September 2025.
kindly
This is not a place to hold conference. Come ready, place your case.
Item number 14.
Is the area in salary on the basis of the higher skill. Or what happened, what I am stating. In the year 1984, I was appointed as an assistant teacher with a master degree in Sanskrit. Malad,
praying for area salary.
Area salary, Malad, in the meantime, so many things happened after my join. In the year 1984, I have joined, Malad, having qualification MA in Sanskrit. But the skill was granted as a graduate skill. Subsequently, by an order of the DI, master degree was allowed. In the year
MA scale was postgraduate scale of pay was granted when?
In the year 1984. With effect from in the year 1995, with effect
What is
from the date of
what
join.
is page 19?
Page 19 is the approval. The
17 August 94. Yes. Yes. How postgraduate scale? What you are praying for area salary? How postgraduate scale of pay was granted to you?
The postgraduate school in the year 1995 with the date from the date of the appointment. It was allowed.
Where? How it was allowed?
My lord, page 95, page 20, on the basis of the memo dated 27 January 1995. The next page, page 21, it was modified. I am entitled to get from the date of appointment. Next page, page 21, on 17th August 1984. So there was.
Yes.
Thereafter, some area in salary, 1 lakh something, I paid for. It was sent to the director of schools at the relevant now commissioner of education. When at the time of consideration by the commissioner, it was set aside of the order of the DI. No, he is not entitled to. I have challenged this. The Honorable Justice Arindam Sinha, in the year 2016, on 7th January 2016, set aside the order of the commissioner. Now, since he is entitled to. In the meantime, I have retired in the year 31st January 2016. Pension payment was issued on the basis of the graduate scale. I have challenged that TPU. Honorable Justice Raja Sekhar Manta set aside the PPO and directing the DPPG to issue the first PPO on the basis of the master degree and also to pay the area all in respect of salary as well as the earlier area and also along with the interest. So, this is the relevant, kindly come to the page, 43 of the Raja Sekhar order of the Honorable Justice. Page 43. relevant page 45. Page 45 is the relevant. refer করে দিচ্ছি। Ultimately to DI কে deputy area আছে সেটুকু আর তো কিছু চাইছি না।
Yes.
So, my lord,
Page
thereafter,
45.
but thereafter, your states preferred an appeal. Appeal dismissed. Next page, my lord, page.
Yes.
Appeal.
Yes, yes.
47.
48.
So, my lord, on the basis of the appeal, yeah, after displaying all these things, my lord, the postgraduate skill was granted and PPO was placed.
Now you want interest.
No, I want, my lord, the area in salary, my lord, for the
File contempt for violation of the order dated 2018
order.
File a contempt.
2018 order.
Show me where the DI approved the engagement arrangement in terms of 57 SES dated 27 January 1995 memo.
That has been already, my lord, Arindam Sinha has been set
Yes,
aside.
that I have heard you. Show me that DI approved the arrangement.
But that point I cannot now at this reopen because that has been already.
Where is the arrangement? There was a judgment of Justice Baring Ghosh.
At the relevant time, my lord,
7
no,
January 1995 cannot be.
page 21 subsequent memo.
Yes, subsequent memo of 1993. Show me where the arrangement has been done.
That has been considered by the Honorable Justice Arindam Sinha, all these points and set aside this order of the commissioner. Commissioner raised that question and set aside this. No paper and appeal against that order. Subsequent order, he has preferred an appeal, so appeal dismissed. So, my lord,
But this point was not taken.
My lord,
show me that this point was considered.
Honorable Justice Arindam Sinha has considered.
Considered?
Yes.
That the arrangement of that the arrangement made by the school authority due to dearth of teacher in that particular subject was approved by DI.
Commissioner, that not point was not raised.
You show me.
Only
The court is asking you.
My lord,
what commissioner has said, forget about it. Court is asking you that where is the approval granted by the DI as envisaged under 27 January 1995.
No, but my lord, after this, my lord, all these things, but now, my lord, it can be open, my lord. I am asking.
No, I am asking you to satisfy my conscience. Where is the approval, Mr. Ali?
Approval is the, my lord, page 9.
Has it ever been considered by any court previously?
It has been considered. I have not gone through at present, my lord, Honorable Justice Arindam Sinha. All these
show me that it has been was considered.
Yes, yes. My lord, the page 35.
Yes.
Page
35
33 onwards.
Yes.
33 onwards. 35.
Yes.
35.
Take me to the relevant part.
Mr. Del and advocate, page 35.
Yes, page 35.
No provision for high skill upon additional petitioner from dated cancellation of such and such. Hence, Mr. De, present, entitled to enhance. He has admitted by the government, entitled to enhance salary on and from 27 January 1995 has been allowed.
Do you have 27 January 1995 circular? It is divided into two parts, column 1 and column Roman I and Roman II.
Yes.
What is contemplated under Roman I? Yes.
At present,
and there was a judgment by Justice Baring Ghosh that school should come with this arrangement before the court, not the teacher concerned. Has it been considered?
Next two lines, Miller, very important in correct page 35, Miller. Mr. J relying on government circular so and so and submitted what has fallen from his lordship. The number of teaching staff for class 4 junior high school was 6. The petitioner was appointed in the 6th post. Therefore, the said post could not to be said to be an additional post. Mr. They pointed out that same was 1992 and could not be gave retrospective effect from the year 1980.
Well, file your affidavit, sir. Affidavit service filed on behalf of the petitioner is taken. Next paragraph. Petitioner prays for uh, payment of arrear salaries, payment of arrear dues in terms of the order passed by a coordinate bench on a writ petition in terms of the order passed by the coordinate bench dated 20 September 2018. Stop. However, it is submitted that calculating last pay of the petitioner prior to his retirement in postgraduate scale of pay. Postgraduate scale of pay was considered while in postgraduate scale of pay, pensionary benefits were released in favor of the petitioner. Stop. According to the petitioner, arrear is outstanding. You have not received arrear.
Area for the period, 1 lakh 2,000. For the period.
According to petitioner, arrear for certain period is out.
Salary also.
Next paragraph. State respondents are represented by learned advocates. Next paragraph. Let affidavit in opposition to this petition be filed by 1 week after ensuing puja vacation. Affidavit in reply thereto may be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging opinions. Yes, school is party.
Yes, I have served.
Acha. For a learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of such others.
Item number 15.
Yes, 27.
What you are claiming?
Page 27.
Yes. Yes.
After your lordship's order, the page 30, DI has forwarded the
Any decision has been taken by the commission?
Page 30, DI has forwarded to the commission that the with fee preference schools. In compliance with your lordship's order, page 33.
No, I have not stated anything. I have directed that to forward the transfer application to the commission.
That is why DI has this.
Yes.
That is 21st March 2025.
Yes.
Now, your lordship, page 31, commission has recommended my name to first preference.
Yes.
And the commission, prior to that, commission asked the school to whether any vacancy is available in the first preference school. After obtaining report from their school, recommendation is made. After that, 18 June 2025, this recommendation was made by the school service commission. The board has not issued transfer.
No, commission has recommended you to the first school for transfer.
For transfer. Commission
that is at page 31.
Page 31, first preference school has been recommended.
Yes. Then now what is the difficulty?
No recommendation has been, no transfer order has been issued by the board. I filed these writ petitions and legal demand notice through learned advocate.
So your grievance is against the board?
Board. Now after filing the writ petitions, after the submission, page 37 of the advocate's demand notice, My lord, the board has intimated, and will also kindly allow me to file supplementary with the board's communication. What is the board saying? My lord, your lordship, my lord, I have prepared a supplementary. What is the board?
No direction is there for
No,
filing.
board has communicated, that is why I prepared it.
May I submit what happened? My lord, we received the recommendation letter for transfer. Now, my lord, in the meantime, what happened? All the vacancies were sent for second SLST. So there were no vacancies. So, my lord, we
Second SLST means 2025 SLST.
2025 SLST. Whatever vacancy were there, or were sent for those. So, my lord, we don't have any vacancy for this transfer. So, my lord, what we did, your lordship, we asked the Commissioner of School Education to send the alternative vacancy for this post. And my lord, in the meantime, my lord, the Service Commission also withdrew that recommendation of the candidate because that particular school vacancy was not available. Now, in the course of time, my lord, this is the letter we have sent. We have sent to the Commission of School Education, my lord, sending name of 7 candidates similarly situated. So, my lord, we have received the alternate vacancy of some of the candidates and are waiting for this candidate. As soon as we get from the Commissioner of School Education, my lord, we and that we will send it to the school SSC. SSC will issue fresh recommendation, and it will be.
So very well, then SSC call the petitioner that since this vacancy is not available, it has been sent for filling up through second SLST, and whatever vacancies which are available, if petitioner opts a vacancy, then the petition is to be recommended.
Case 30, there are 3 preference schools. That is why the board has recommended the school withdraw my recommendation that that first school has been reported to the second SLST. But what about the second and third? Don't know, the communication has been.
So you are yes, that's why I will direct the file it.
That is why
I will direct the chairman, since the vacancy in the first school is not available. If vacancies in 2 other schools are available, in that event, petitioner should be permitted. Otherwise, other vacancies which are available will be disclosed to you along with the vacancies in 2 other schools, if those vacancies are available. And if you opt for a school for your transfer, in that event, an appropriate transfer order is to be passed. Yes, that will be if vacancies are available. Whether the vacancies in other two schools are lying.
Well, that
my instruction that is still available.
That will be again, my lord, your lordship, my lord, direct that or any other.
No. Whether the vacancy in other is a pertinent question because
medical grounds he is suffering from cancer.
Due to vacancy. Because if Barlow Girls High School there is no vacancy, then in Malda, UCB and Railway Girls High School, whether vacancies are lying or not. Yes, Mr. Boisho, I am taking often instruction come back. If vacancies are there in 2, second and third, they'll have accommodate the petitioner in one of the 2 vacancies. That's not. Affidavit of service filed on behalf of the petitioner is taken on record. Next one. A supplementary affidavit is filed on behalf of the petitioner, which is also taken on record. Next paragraph. As per transfer application of the petitioner, though he was recommended to Barlow, page 30 to Barlow Girls High School within bracket HS close bracket Malda. Vide memo dated 18 June 2025, but subsequently it was found that said vacancy is not available. Stop. Learned advocate representing the petitioner submits. If vacancies are available in vacancies in second and third preference schools are available as per transfer application of the petitioner, petitioner is willing to be transferred to one of those 2 vacancies. Next paragraph. Mr. Boisho, learned additional government pleader representing the state respondents, is directed to obtain instruction whether vacancies are available in Malda UCB High School within bracket HS and Railway Girls High School or not. Vacancies are available. Stop. List the matter for further consideration under the same heading on 10th September 2025 in order to enable the learned advocate for the state to obtain instructions. If vacancies in two other schools are available, vacancies, then there is no need to find out other vacancies.
Here is later 21st March 2025. After 2 months, SLST notification has been got. The delay caused by the authority the unnecessarily fast paper has been put.
Next matter.
Item number 16. No compliance report, only for the vacancy report.
Only, yes. Obtain instruction and place it before this.
Already this matter my lord decided and recent that is not published. Molecule matter, my lord, the last day retirement regarding compassionate appointment.
I am for the district primary school council.
Order, my lord, order. Page number 52 is the denial order, the instant petition, my lord. Although in the earlier in molecule matter, my lord, school service commission appointment letter was there because
it is also on the last date.
On the last date. Here is different. That the molecule matter 1961 and this matter 1964. This is only different. Although I came up with some correction.
No appeal was preferred against this order.
Even compliant. As per my, yes, as per my instruction system. No, although there is not get appointment, but with communication.
My lord, this is a rejection order by the district primary school council.
District Primary School Council?
Yes. No.
Yes, Lord. Yeah,
Kindly see page number 51. 51 and 52. 51 and 52. That is the order, madam. Because my lord will elaborate.
The Birbhum District Primary School Council.
Yes, my lord, district secondary. Because of that, my lord will remember 2009 rule. Because every teacher compassionate appointment in the group C, group D post, my lord. So that's the kindly term, page number 51.
No. There is an option also.
Yes.
A teacher, candidate can prefer to be appointed in primary school as teacher.
But this is not a primary school. It is secondary school. Kindly page number 51.
Secondary school.
Yes.
Secondary school.
50, current page number 51.
No. Since the order is passed by the chairman DPSC, very well, it's a secondary matter.
Yes.
Because consider your appointment might have been considered for in a secondary school. But since order is passed by the chairman, Birbhum District Primary School Council, chairman should be added as a party.
Yes.
Chairman
And
will
the
appoint party.
kindly
Have you added chairman as party respondent?
Yes.
Who is
The
appearing
paid
for?
party. I am appearing for the chairman.
But this order, my lord, essential.
You are appearing for the chairman.
Yes, Your Honor.
Essential is a secondary. Because why? Because of that, we want.
I understand that your application for transfer for appointment on compassionate ground was considered against a vacancy in secondary school.
Yes. Yes.
It is petition.
And page number 47 onwards.
First of January, which is
Primary education bill. Jani. 2009. আমি জানি না এটা কোথায় হবে।
Fifty onwards. Page 50 तो ये package. এটা রিজেকশন না, এটা কোথায় রিজেকশন? এটা কাউন্সিলের রিজেকশন, রিজেকশনটা তো ওই কাউন্সিল না পাঠালে আমরা পাঠাবো কি করে?
So as per norms, if date of birth is 2nd January 1964, then petition date the concerned teacher, primary teacher, attained age of 60 years on 1st of January 2024. If it is on 1st of January 2024, the teacher is to retire on 31st of January 2024, not on 1st January 2024.
No, madam.
And if date of birth is 2nd January 1964, in that event, on 1st of January 2024 was the date when teacher attained 60 years. If teacher dies on that day, petitioner is entitled to get appointment. How the chairman has said that his prayer for appointment on compassionate ground for the post of group C in any secondary is not considered in the light of the it is stated that which is not before. Last sentence, as the date of birth of the deceased teacher is 2nd January 1964 and the teacher died on 1st of January 1964, 2nd January 1964 and teacher died on 1st of January 2024, which is not before the date of superannuation. Why? It is on the last date of superannuation.
But my lord, this
If
rejection,
a teacher retires on 1st of January 2024.
my lord, in my humble submission, my lord, this is a rejection made by the council. This is a council's rejection. My lord,
No,
not,
no.
yes, my lord,
Come,
kindly
come to first, second, third paragraph. What your DI has said, secondary. Later on, the office of the district inspector of school AC Birbhum has returned the proposal to the office of the district primary school council Birbhum through the district inspector of school primary education Birbhum to revisit the eligibility criteria.
Yes.
It was returned by your DI, the DI secondary.
For visitation.
Issue is decided by this court. Then your secondary DI could have passed an order rejecting the prayer of the petitioner. He chose not to do this for send it back to the district inspector of schools primary education Birbhum, and then primary education then the chairman of the district primary school council Birbhum decided no, you have that you are not entitled since did not date of death was after retirement. On what basis he is saying? If date of retirement is say 1st of January 2024, then petitioner died on 2nd of January 2024.
My lord, kindly, my lord, keep it on Monday, my lord. I will come before your lordship, my lord. Because, my lord, I was on the first.
Take instruction in the light of the judgment. I have decided the issue. Already issue is decided by this court. Issue.
My lord, except Monday and Tuesday, my lord.
Very well. Matter is heard in presence of the learned advocates representing the parties. Stop in the writ petition. Memo dated 24 June 2024 5 issued by the chairman Birbhum District Primary School Council is under challenge. Stop. It needs to be stated herein that by memo dated 24 June 2025, prayer of the petitioner for appointment under compassionate ground against a post of Group C or Group D? Group C. Against the post of clerk within Group C in a secondary school, within bracket Group C in secondary school, was turned down. Stop. Next paragraph. Learned advocate. Next paragraph. Learned advocate representing the petitioner submits that issue is no more res integral in view of the judgment delivered by this court on 26 February 2025 on a writ petition being WPA 28275 of 2024, 28275 of 2024, within bracket Sheikh Monikul Hussain versus the state of West Bengal and others. Next paragraph. Mr. Dhol, learned advocate representing the state respondents, has prayed for accommodation to obtain instructions. List the matter under the same heading for further consideration on 16 September 2024.
My lord,
After 14th.
My lord, except 16.
Every day mentioning.
My lord, cannot be on 17th, my lord, one day, my lord. Because 16th, my lord.
You have difficulty?
Yes. Let it be on 17th.
Yeah, let it be 17th.
I am different.
Please, after original side.
Any original side mentioning? Listed matter, adjourn motion specially assigned serial number 1, Sujasha Mukherjee.
Of High Court Administration.
Yes, who is for the petition? Advocate on record. Yes, place your question.
We are questioning the maintainability also. Because just indicate in one line. A disciplinary proceeding is going on against the writ petitioner. They want disclosure of a document through writ petition where the witness action is going on in the disciplinary proceeding. This is what is the actual purpose of the writ petition. The writ petition is founded on an allegation that the decision to initiate disciplinary proceeding was not a full court decision. That's the basis. Now, whether or not there is a full court decision, we have to disclose in the disciplinary proceeding. They want to just fish out that evidence here.
First of all, whether this is a
Just a minute. Yes.
First of all, my lord, on basis of the question of maintainability, what my learned senior friend has just pointed out, whether this is at all a piece of evidence, because whether it's a cross-examination is going on, and whether it's a disputed question of fact, which can be brought out in cross-examination, that would have been a piece of evidence, and I
Why
cannot.
at this stage court will embark upon this?
Worship, our humble submission is that the basis of the departmental proceeding, whether it has a mandate of law or not, this is not a disputed question of facts. This is a question which strikes at the base of the disciplinary proceeding, whether there was a resolution or not. Nothing will come out of the cross-examination or examination of the witnesses. Witness cannot build upon this. This is the basis on which the departmental proceeding stands upon. So we have been asking for this because during cross-examination, one of the witnesses said that he's not aware of it.
So you are questioning the initiation of disciplinary proceedings since it is not backed by full court resolution.
Lordship, and I also have disclosed by way of a supplementary affidavit that we had applied for that under the Right to Information Act. There also no clear answer has come up.
Under what provision this it is required that the full court resolution is required to be taken prior to initiation of
Lordship, under the appellate side rules.
Show me.
To the administrative committee, Lordship, it's at তোমার appellate side rules এ Rule 1, chapter 1, rule 3.
Yes. Which rule? Rule 4.
The departmental proceeding, Lordship, it's clearly stated that.
Which rule you are relying upon?
Rule 4, Rule 3 and Rule 4. Administrative committee, in order to take a decision, has to take a decision in respect of a disciplinary proceeding. And an administrative committee's decision, Lordship, has to be backed by a resolution.
It says rule 3, D says that to make recommendation for disciplinary actions, including degradation and suspension against members of the higher judicial service and state judicial service, administrative committee shall have the power. Yes.
But here, Lordship, it is
So
not,
no full court resolution is required.
Lordship, here no administrative committee, nothing has been there. It was only nothing because administrative committee, in order to take up decision, there has to be a full court resolution.
But at this stage, whether there is an administrative committee decision.
But I have instructions not to divulge now.
What?
But my lord, everything is in order.
So let the issue be kept open and let the disciplinary proceedings be concluded. You will have the chance to, who knows that at the end of the disciplinary proceedings, you may be exonerated.
Why I'm saying
So therefore, let the proceedings which has been initiated,
So the
let
mature
it be,
stage.
let it be concluded. Let the proceedings be concluded to its, let the proceedings be taken to its logical conclusion. And thereafter, I am making this, I am keeping this point open for consideration. Ultimately, if decision goes against you.
To kindly appreciates only one thing, that's I have been kept under suspension for more than 2 years. The suspension order has not been revisited by the appointing authority at any point of time. When I am asking for the basis of the proceeding, I have been said that they will keep it.
Yes, because it's a premature stage.
And also
At this stage, first of all, unless and until suspension order is without jurisdiction or malafide, you cannot challenge it. Suspension order. Second, disciplinary proceedings initiation at this stage when the when this inquiry is going on.
Witness action is at the mature stage.
So when the inquiry is going on and witness action is at the mature stage, at this stage it's a premature stage. So therefore, if ultimately proceeding after conclusion of proceedings, you shall be at liberty to question whole hog entire thing.
Everything. But kindly appreciates one thing is that whether at all this is a piece of evidence that can be kept as a secret, like it's not.
It's not a secrecy.
At
It's
this
not
stage,
about
it's not required because witness action is going on in connection with the inquiry proceedings. Let the proceedings be taken to its logical conclusion, and I am keeping this point open. If the final order passed is adverse to the petitioner, in that event, this point can be urged at the time of questioning the final order on conclusion of disciplinary proceedings. Why at this stage it is required? Who knows that the outcome of the disciplinary proceedings may not go against the petitioner?
But only one humble submission. But right to initiate a proceeding is of course not in the domain of the inquiry. The very few limited grounds on which not one can challenge the initiation of proceeding is lack of authority.
That is what I am telling to you, junior.
I'm not. This has been questioned. Prima facie materials available before this honorable court is there was none. There was no decision taken to initiate disciplinary proceeding by the competent. Of course, not the administration can say that there was a decision taken to do so. And that's a question at which your lordship may have to decide finally. I'm not. I have participated to a certain extent, no doubt, but it came out in the inquiry proceedings that this has not been done. So this is something which was not within my knowledge when I have done this. But may I submit this? But I participate. At the end of the day, if it is found that this was suffering from lack of authority or jurisdiction, then what the entire proceedings go not away. So not the balance of confidence. I have participated to a certain extent. Not witness action is yet.
So let the proceedings.
Let the final order not be passed.
Let the proceedings be taken to its logical conclusion.
Final order is
Even
passed.
final order may come in your favor.
May.
So let it be known.
But I am subjected to an inquiry.
No, and not at this stage. Court will
I'm
not,
I'm
court will
praying
not
for a
delve
stay
into,
at this
court
stage.
will not delve into this issue at this stage, Mr.
I'm
Mujumdar.
not praying for a stay of operation of this order or the further proceedings. But the proceedings may go on, but not a final order to be passed.
What is the suspension order?
Yeah, that's 2.5 years.
No,
back.
Mr. Mujumdar is there. Let me ask Mr. Mujumdar to point it out.
And it's at page 16, 11th of September 2023. Please come to the last paragraph of page 16. Therefore, this is really not the basis of the proceeding.
Last paragraph at page 16.
But this is the basis of the proceeding. There is a reference to a memo of 20th of June 2023. Then not please come to the this paragraph at page 17. Honorable High Court is pleased to place you under suspension. Samrat, please see the chart sheet at page 18.
Just a minute. Now, in the written statement, you have taken this point.
But it came in the I proceeded on the basis that whatever is there at page 18 is not is correct till it surfaced in the inquiry proceeding. Please come to page 18.
But your written statement is devoid of this
Because I
claim
didn't know.
that where is the decision of the appropriate committee.
It came in course of cross-examination. It came in the course of cross-examination at the inquiry, but this had not been done. Please come to page 18 once, and I proceeded in good belief that whatever is there is true and correct. The first opening line of page 18. Pursuant to the direction of the Honorable High Court. Then the second paragraph, Srimati so and so is required to submit a written statement in support of her defense, if any, before the disciplinary authority.
Yes.
Then the third paragraph, the fourth paragraph is hereby informed that if she does not submit her written statement on or before the specified so and so date, or otherwise fails or refuses to comply with the provisions of the rules or directions issued, the disciplinary authority may hold the inquiry against her expert. Similarly, I proceeded on the basis that the disciplinary authority, being the High Court, had taken a decision to initiate proceeding against me.
Just a minute. Yes. In the event no response is filed.
I proceeded on the basis that the High Court, being the disciplinary authority, had taken a decision to initiate a proceeding against me through the departmental charge. When I come to know of this, I have taken this point. Now, this is only at the stage of the PW1 deposing before the inquiring, before the Honorable Judge. So, I raised this point. I filed the reputation saying that the proceeding has been initiated without the authority as prescribed in the rules.
Lord, initiate has been explained in so many judgments, not only in the context of service discipline.
So
but
there is a presenting officer and a presenting officer. So he will meet these points before the inquiry officer.
The inquiry officer cannot decide on the question of jurisdiction of the disciplinary authority. He is a delegatee of the disciplinary authority to collect materials, normal parlance. Because the ultimate decision to take a final call on the
No, the report will reflect the response of the presenting officer, based on which the disciplinary authority will take decision.
he is probably not in a position to decide on his own competence or jurisdiction.
Who?
The disciplinary authority. The disciplinary authority has initiated a proceeding on the administrative side. I am questioning the authority of the disciplinary authority on the judicial side.
No, first of all, this in your response to the charge sheet, you have not taken this point. On good faith, you offered your response to the charge sheet. Then during the during inquiry, this point was urged by the petitioner before the authority,
And
before the inquiry officer. Now the
no, it came as in cross-examination to the witness. When the file was placed, I said that has this been placed before the so and so?
So during witness action, this this was surfaced. The question came up, and then this point was taken by filing this writ petition. So let the inquiry be concluded.
In the event,
Taking a cue from a witness action, whether you can file a writ petition.
whether the authority has decided or not, it's a question of fact.
So that issue I am keeping open.
It's a matter of record. Not
That issue, Mr. Mojumdar, I am keeping open at this stage. I am not. I will make a specific observation that nothing is decided. All points are kept open. Only disciplinary authority and the inquiry of a disciplinary authority will be permitted to conclude the proceedings.
But he concludes the proceeding. My question, the issue raised as regards the authority under the authority to initiate the proceeding. But I don't have another issue. It's only the court on the judicial side which will decide.
Yes.
Well, since I have not used any affidavit, will all allegations, sir.
Writ petition is heard in presence of the learned advocates representing the petitioner and High Court administration. Stop. State respondents are also represented. Stop. In the writ petition, order of suspension dated 11th September 2023 and charge sheet dated 11th, also dated 11th September 2023 are questioned. On the scope that initiation of disciplinary proceeding is not backed by appropriate, is not by the decision of the appropriate, is not by the decision of the competent committee
Serial number likhe din
of
Oh, acha.
High Court.
Thank you, madam.
Stop. Or appropriate competent committee, appropriate committee of High Court.
My lord, kindly say appropriate authority of High Court may not be a committee. Appropriate authority, my lord, of High Court.
Stop. In this regard, notice of this court has been drawn to Rule 3.
Probably chapter 3.
Under chapter 1
Yes, chapter 1.
of Appellate Side Rules, High Court at Calcutta. Wherein it is provided under Rule 3 within bracket small d that administrative committee shall have power, with reference to the judges generally to make recommendations for disciplinary action, including degradation and suspension against members of the higher judicial service and state judicial service. Stop. Next paragraph. Mr. Mujumdar, Mr. Homo Mujumdar, learned senior advocate representing the petitioner, submits that suspension order was issued on 11th September 2023, and on the same date, charge sheet was issued, and in response thereto, written statement of defense was submitted by the petitioner. So, it is also fairly submitted that in the written statement of defense, whether disciplinary proceeding was, whether disciplinary authority was authorized to initiate proceedings against the petitioner was not questioned, but in connection with inquiry proceeding, or but in connection with inquiry proceeding, when witness action was going on, based on surfacing certain materials, petitioner found that their petitioner found that disciplinary authority might not be authorized appropriately to initiate proceeding against her, which triggered the present writ petition. Stop. A specific point is urged before this court that disciplinary authority is not duly authorized by the concerned authority of High Court to initiate proceedings against her. Stop. Petitioner prays for disclosure of relevant materials in order to satisfy the requirement of authorization which was made in favor of the disciplinary authority for initiating proceeding against the petitioner. Stop. High Court administration experiment. High Court administration is represented by Mr. Siddhartha Banerjee, learned advocate, who has opposed this writ petition on the count of maintainability, and it is also submitted that writ petition is it is also submitted that writ petition is premature. Stop. Next paragraph. Another limb of submission which is advanced on behalf of the High Court administration is that during witness action in connection with inquiry proceeding, during the in relation to witness action in connection with inquiry proceeding. A point is agitated in the writ petition that perhaps disciplinary authority was not authorized to initiate proceeding against the petitioner. Next paragraph. While considering the respective submissions made on behalf of the petition, made on behalf of the parties, and taking note of the fact that inquiry is still going on, and taking note of the fact that inquiry is still continuing, comma, appraising the situation, this court finds this is not the appropriate stage to scrutinize whether disciplinary authority was authorized to initiate proceedings against the petitioner or not. Taking note of the fact that challenge has been laid to the suspension order and charge sheet, nothing is demonstrated that suspension order and charge sheet are without jurisdiction, and no case is made out, and no case relating to malafide is made out. Stop. Therefore, court finds it not appropriate to interfere with the disciplinary proceeding which is continuing against the petitioner at this stage. Stop. It may so happen that on conclusion of disciplinary proceeding, final order may be passed which will not be adverse to the interest of the petitioner. Stop. Therefore, at this stage, entire issue is academic. Next paragraph. Hence, writ petition stands dismissed. However, it is made clear that issues raised in this writ petition are not decided and kept open, which can also be raised if ultimately order passed on conclusion of disciplinary proceeding which is adverse to the interest of the petitioner. Urgent xerox certificate copy.
All allegations in the writ petition admittedly.
একটা করে দিন, since no affidavit is called for, allegations contained in the writ petitions are deemed not to have been admitted.
So grateful to your lordship, grateful.
I'm keeping this book, Mr. Mujumdar will get it back. So it is High Court rules.
It's not mine.
Great.
এটার সঙ্গে পাঠাবেন, আবার দিয়ে দেবো।
My lord, mentioning one matter, my lord. Yesterday, my lord dismissed one petition, and those matters are now moving before court number 11. So here are two.
By code number 11, you are saying you should submit that it is to be put before the
I
honorable
apologize,
division.
my lord. Before the division bench.
Yes.
I apologize, my lord. My lord, kindly, there are two matters. I have two matters. Kindly, if your lordship could allow.
Yesterday, I disposed passed certain orders
Yes.
on 4 matters.
Dismissed
Yes,
4, 5,
dismissed
6.
4 matters,
Yes.
out of which 2 matters will be moved tomorrow.
Tomorrow before the division bench. So I am praying before your lordship that there are two matters, my two matters in writ petition. Those are to be moved in your lordship's court tomorrow. But if your lordship could allow to move before the division bench directly.
No, sorry.
Transfer the matter kindly.
That is
my
not
lord.
possible.
Kindly, my lord.
No.
Kindly, my lord.
No,
This is urgency, otherwise I would not have.
sorry, please call
My lord,
this.
kindly, my lord. My lord.
Please don't mention, it is
My-
not the mentioning time.
My lord, kindly, my lord. With folded hand, my lord, with folded hand, kindly, I am mentioning before
Yes.
lordship.
Call the list.
Kindly, my lord. This is emergency, urgent.
It is on your mentioning, it is included in the list.
My lord, kindly, my lord. My lord, kindly.
On your, if order comes from the honorable division bench, then I will pass order.
My lord,
Otherwise,
kindly, with folded hands, my
if
lord.
order passed from the honorable division bench, don't embarrass this court in this fashion. If order comes from the honorable, is কোনো order page or division bench? If order comes from honorable division bench, as it comes from honorable Supreme Court, that all the matters to be transferred, then I will transfer it. Not before that.
May I leave to file
It is not a place to have time to mention. Under the special circumstances, he is mentioning.
Item number 17.
If any order passed by the honorable division bench in connection with those appeals, then you mention this matter. I will immediately thereafter release the matter. Yes, try to appreciate my predicament too also. Yes. Wait, let the matter be called on. Item number 17. Yes. Yes. What is the matter? Is order of transfer? Where is the order? Where is transfer order was issued and subsequently it was cancelled? Page 38.
Having considered the submission made by the SPT party, it can dispose of directing the chairman to inform us citizens to constitution, being responsible for all the commission for 30th for recommending card to another school or disposing in mutual right. Thereby, the place of picking it is having completed by the court by each of the passing to opposite order.
Yes, whether petitioner was called.
My lord, yes, my lord. Kindly turns to page 12, para 18.
Para
18.
Paragraph 18.
18. My lord, kindly
Just a minute. Yes.
Kindly,
What does it mean? Petitioner
I'm also not.
appeared on 11th September. White letter date asked the petitioner to attend the office on 19th September.
September
Petitioner
1.
appeared. Then whether the
Thereafter-
vacancies were disclosed.
Yes, my lord, disclosed. My lord, since she has not, my lord, choose any vacancy, my lord, she was, my lord, kindly turns to page 40, my lord. My lord, School Service Commission requested the District Inspector of Schools to forward certain vacancies so that petitioner may be accommodated in the vacancies. And my lord, District Inspector of Schools, my lord, forwarded a vacancy.
So vacancies which were disclosed on 19, these were not none of the vacancy was opted by the petitioner. Thereafter, via letter dated 26 December 2024, another vacancy was disclosed to the
Disclosed
petitioner.
to the petitioner.
Yes.
My lord, kindly turns to page.
Now what petitioner wants?
She is not willing to join the said vacancy.
On 19th September, no option of vacancy was given to the petitioner. Subsequently, one vacancy was around 30 kilometers from place of petitioner. And whereas another vacancy is lying just documentation house of petitioner, which is answer 42 years. Petitioner got it on the RTI Act. That you know, so
All vacancies cannot be offered to you because there are vacancies which are in the pool of 2025 recruitment second SLST. So wherever you are finding vacancy, that cannot be offered to you for your transfer. If that vacancy is within the pool of second SLST, that cannot be offered to you.
No secondary vacancies in the same subject. Sanskrit. Kindly see that.
Now what you are praying for?
I'm paying for customer service.
Yes.
This vacancy exists.
No, that will not be whether the court directed that
to give some option.
to appear before him to call the petitioner to appear before him for re-recommending her to another school on disclosing available vacancies to the petitioner.
No available vacancy is shown on the date of September. After
According to your specific choice, vacancies cannot be offered to you. Whatever the vacancies which are offered to you, if you are willing, then court can direct. Otherwise, not. That is neither here nor there. Where you have stated that no option was given to you in the writ petition.
That was
No, where you have stated, then why you are making submission beyond the record? Because it relates to fact. So it has to be based on the statements made in the writ petition, where you have stated that no vacancy was offered on 19th September 2024. Have you stated that no vacancy was shown? Read paragraph 18.
And after attended a meeting, nothing has been stated. But fact remains, if there is vacancy shown that after 3 months that vacancy should not be confirmed to the petitioner. Kindly see page 2. The vacancy declared on 26 December 2024.
You have not stated. You have not stated in the writ petition that no vacancy was shown to you. Then why you are making a submission which is not supported in your supported by the averment made in the writ petition?
On 26 December vacancy has been shown.
So are you willing to join the post, join the vacancy as it appears from memo dated 26 December 2024?
And the police have to join there if my nearby place of.
Are you willing? Then court will direct. If you are willing. But I will keep this matter pending. If you do not join, then a heavy cost is to be imposed.
Then I have to take instruction. But vacancy is there in nearby place of residence. That is 30 kilometers, but there is no direct means of communication. It will take another.
Issue. File your affidavit service.
Yes, Mr.
It is a case of re-recommendation. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, it is a case of re-recommendation. Since petitioner could not join the post on transfer in terms of previous recommendation. Stop. Taking note of this fact, first writ petition, taking note of this fact, writ petition being WPA 16067 of 2022. Was disposed of, directing the chairman, West Bengal Central School Service Commission, being respondent number 4, to call the petitioner and disclose available vacancies, disclose available and suitable vacancies, where petitioner can be accommodated. Stop. If petitioner opts a vacancy, on disclosure of vacancies, appropriate order shall be passed, permitting the petitioner to transfer to the said vacancy. Stop. Next paragraph. In terms of the order dated 29th August 2024, passed by this court, petitioner appeared before the chairman on 19th September 2024, but the petitioner did not opt for vacancies which were disclosed to her. Stop. As a result, as a result whereof, necessary order could not be passed by the respondent number 4 for transfer of the petitioner. Stop. Subsequently, Secretary of West Bengal Central School Service Commission, with a memo dated 26 December 2024, informed the petitioner that a vacancy in Borishali High School, Purva Bardhaman, is available, where petitioner can be transferred on re-recommendation. Next paragraph. Now, stop there. Next paragraph. Now, stop. It is submitted by the learned advocates representing the petitioner and commission that till date petitioner has not expressed willingness to be transferred to the post in Borishali High School, Purva Bardhaman. Stop. Next paragraph. Leave is granted to the petitioner to express her willingness by fortnight from date for her transfer to Borishali High School, Purva Bardhaman. Stop. In the event petitioner's willingness is communicated to the respondent number 4 within the aforesaid time, respondent number 4 is directed to pass an appropriate order permitting the petitioner to be transferred to Borishali High School, Purva Bardhaman. Stop. In the event no willingness is expressed within the aforesaid time, commission shall be at leave or respondent shall be at leave to utilize the vacancy otherwise. Next paragraph. With the aforesaid directions and observations, writ petition stands disposed of. Wording directed.
Item number 18.
Hold on, the petition in this matter. Kindly come to page 81. The single subject teacher was returned. Praying for 3rd January. 81.
Yes, page 81.
Yes, my lord, it has been returned on the ground of single subject teacher.
2021 application. What DI will do now?
Ending, my lord.
His last application was made applicant to HY 26 December 2021.
I understand.
Yes, that is apparent from this.
Because since once commission had returned, school will not dare to send me again on the same ground. I understand. Your lordship has considered these matters. Till date, no. I mean,
Now you may not be a single teacher in.
I am a single teacher. I've stated I am a single subject teacher. Admitting that I'm a single subject teacher. 3rd January has to be followed. Your lordship has considered.
Where are the teachers from neighboring school?
He found there only.
Come up with a writ petition making the willing teacher as private respondent. Appropriate order is to.
I cannot do. I will have problem while going to school there. Neighboring school.
Only one case I have found that a teacher is found. Only
one case. But no,
perhaps you are appearing.
Possibly, yes. No, my transfers are being done.
Part-time teachers and all those teachers are there.
No, the arrangements are usually ultimately made.
So let me direct the commission to arrange a teacher as a special.
You know,
Based on your submission. Based on your submission.
It's for the state.
So then you are in a better position.
Now, I'm for the commission.
You are in a better position, Mr. Mitro.
Today it's a double barrel gun. It's from state, he's from the commission.
And also petitioner.
I am nowhere.
Affidavit of service filed on behalf of the petitioner is taken on writ. Next paragraph. Petitioner made an application for transfer on portal on 26 December 2021. But it is submitted by the learned advocate representing the petitioner.
Back to DI মানে কি?
That
back to DI মানে
school authority where petitioner is presently working till date has not forwarded said transfer application to the concerned district inspector of schools. AC Purbo Medinipur. Purbo Medinipur.
দেখো
Being respondent number 5.
পূর্ব বর্ধমান মালা পূর্ব
Purbo AC Purbo right. Purbo Bardhaman. AC Purbo district school AC Purbo Bardhaman. Purbo Bardhaman being respondent number 5. Stop. it is submitted, perhaps reason is, it is submitted, perhaps it is submitted. Reason for not forwarding transfer application to the respondent number 5 by the school authority is petitioner is single teacher in the subject in the school. Next paragraph. Respondents are represented by learned advocates, and it is contended that if applicant teacher is a single teacher in the subject in the school, school authority is required to forward transfer application to the concerned district inspector of schools SC for taking steps in terms of government notification dated 3rd January 2020. Stop. Next paragraph. In view of submissions made on behalf of the parties and taking note of the notification dated 3rd January 2022, 3rd January 2022, head of the institution of Kashem Nagar BNTP Girls High School, within bracket HS, Purbo Bardhaman, being respondent number 6, is directed to forward transfer application of the petitioner by fortnight from the date of communication of this order in offline mode. Stop. On receipt of transfer application, respondent number 5 is directed to make endeavor to find out teacher of neighboring school who can be deputed in place of the petitioner. Now, who can be deputed in the school of the petitioner, to facilitate petitioner's transfer. So, if teacher is found from neighboring school and deputed in the school of the petitioner, petitioner shall be transferred immediately thereafter in accordance with law. Writ petition stands disposed of.
The last application, if not clear, whether
Now you are submitting.
No, that is found, madam.
Next.
Item number 19.
Lordship, in item number 19, I am for the petitioner led by learned advocate Mr. Partho Sarathy Das, my lord. I am praying for 1 week accommodation. He is not well, my lord.
What has happened to him?
My lord, he came to the court, but after that he lost his sense, my lord. That's why he went to go.
He sits in which bar?
Yes, my lord. Bar number 1. Bar is 1. 18 years. Lordship 18.
Partho Sarathy Rai.
Partho Sarathy Das.
Issue. At the time of call, accommodation is paid for. Since learned accommodation is paid for on behalf of the petitioner, since learned advocate is unwell. Next paragraph. Respondents are represented by learned advocates. Next paragraph. List the matter under the same heading for further consideration. On 22nd September 2025.
Great.
Next.
Item number 20.
I'm for the petitioner.
I'm for this statement.
It's 78.
Yes.
is as clean as the status page 78
though my lord,
forwarded to the commission on federal ground, group D stuff. It is pending for consideration since portal is suspended. It has not been allowed.
Distance ground.
Distance ground. Page 78.
though the application is pending before the commission, but the commission has received one letter request from the school authority. So there are two group D staff. And one has lost his job, my lord, and presently there are only one.
Then how it is possible if it is no transfer on the ground of distance? Because he will be the resultant vacant. There will be no group D staff in the school.
But the rule does not cast.
Yes.
No, 6-2C is for teaching staff. Is a group D staff.
Where is 6-2C?
Page 42. 2C is only for teachers.
Page
42. And 3rd January is also not for non-teaching staffs.
It says, Mr. Lahiri, Rule 6 says procedure for submission and consideration of application.
Yes.
It is not confined to teacher.
No, 6-2C.
Then 6-1 says an incumbent may apply for transfer
right
or for transfer on grounds and manner mentioned in Rule 4.
That is my submission.
4A to D. Then
Yes.
Then the respective authorities involved in the process of transfer. School managing committee.
Is my submission. It is for incumbent for all. But when it comes to 6-2C, that is the legislative intent
of application of
to put the bar on teachers. That is my submission.
Consider number of subject teachers and role strength, full stop.
That is my submission.
Full stop.
Yes.
Consider number of subject teachers and role strength, full stop. If resultant vacancy of a school in particular subject becomes
Vacancy in subject. That is why 6-1 says for all. But when it comes to 6-2, it is limited to teachers. Now, my lord, 60
it's not properly drafted.
I cannot help, my lord. That is a state's obligation to.
Not happily drafted.
Possibly. I do not know, my lord. Only one submission. Now, it has been the 3rd January follows 6-2C. There also it says the teachers. So that is a legislative intent.
These
You cannot go beyond
This read petition, my lord, requires affidavit, my lord. I want to file it.
Baba.
Because, my lord, 3rd January is not
Something
applicable,
not
my lord.
done.
It is the submission of Mr. Lahiri.
Yeah, whether 3rd January is confined to teachers only.
Teachers only.
That is why I am submitting now, my lord. If they had allowed me on 2022, today the situation would not have come. That 3rd April Supreme Court judgment.
Then if
What were
3rd
they doing
January
so
is not extended to the non-teaching staff,
Yes.
then the non-teaching staff shall be rendered remediless
Remediless.
in
Yes.
case of single teacher.
For that
Yes.
reason,
That's why taking cue from 6-2C, 3rd January is confined to teachers.
Teachers. It says also teachers. Now, if they had
because, my lord,
But kindly appreciate our mother predicaments, my lord. But this,
It cannot be stretched beyond the periphery of teachers.
we will not be able
if they had
my lord, but ultimate
Procedure for submission and consideration of the application. Very well. Then an incumbent may apply. Includes teaching, non-teaching staff. But when it comes to 6-2C, it is confined to teachers.
my lord,
It
ultimate
says if resultant vacancy of the school in particular subject,
object. Yes. That is my submission, before your lordship.
and in order to give a succor, this 3rd January 2022 was issued
That was issued under
for
62C.
containing a provision
Yes.
for transfer on providing local arrangement. So therefore, so far this teaching, non-teaching staff is concerned,
There are no rule.
this is,
There is
this
no bar.
rule is silent.
Rule is silent.
No bar imposed.
There is no bar.
Yes.
But my lord, ultimately, my lord,
Commission
My lord-
may be directed to take. Otherwise, we will not be practical exams at school. Only one group is staff. So they take the commission.
my lord, if
I
my
will
lord,
do
there
one
are
thing. I will do one thing. I will direct the secretary to take the secretary's party.
Secretary of the.
Yes.
Commission becomes happy if secretary is directed.
Then my lord, leave me. Chairman, I have made.
Yes, chairman is party.
Chairman.
Well, I'll add
Yes,
secretary
leave
as
may be
party,
granted, ma'am.
and secretary will be directed to hear petitioner as well as school authority and pass on.
My lord,
Yes, ma'am.
then also it would
Yes,
be difficult. It would be difficult for me.
because ultimate
staff
consideration
will
is
not
my lord
be-
the student.
my lord,
Prime
if they do-
consideration
my
is
lord,
the
My lord, it does not
interest.
lie.
See again what order comes from the
My lord, it does
secretary.
not lie in the mouth of the commission. 2022, if they had allowed, today the situation would not have come. Now, how can they say this today? 2020
Clerk or group D?
Group D stuff, my lord. Kindly, my lord, he will not be able to substantiate his claim before the secretary of the commission, my lord. Kindly, your lordship passes the order, my lord. Kindly, lordship may direct them to bring a new staff. No problem.
Today morning also, your
What will
lordship has passed a similar order, my
They
lord.
will bring food and other things for teachers. In
Who
this.
will open the
Okay,
door
well,
of the school?
My lord, and now even the school Zomato comes and delivers food. I have seen by my own eyes. Food is
Group D.
Group D. There is no bar in the law.
So,
অবশ্যই
ঘন্টা বাজাবো।
affidavit of service filed on behalf of the petitioner is taken on. Next, for a petitioner,
ইয়ে স্টেট বলছি ইয়ে
application for transfer,
কমিশন স্কুল সার্ভিস কমিশন
being group D staff of
আপনি কি স্টেটে না স্কুলে স্কুলে আমার সিনিয়র নেই
দেখি 51 নম্বর লিখে দিয়েছে কে
one group is clamoring for appointment, having lost job, and other group is on being appointed transferers.
My lord, who is responsible then? The state authorities.
and another
No
group
proper,
without joining fighting for increment.
no proper arrangement.
Yes.
Appointments are tainted. What can be done?
Every service filed on behalf of the petitioner is taken. Petitioner being, ওই কি বললাম কি বলছিলাম বলতো? Being group
পুরনো
being group D staff of Danichok সংগঠনী হাই স্কুল উইদিন ব্র্যাকেট HS পশ্চিম মেদিনীপুর on portal on 16th September 2022. But why school authority gave no objection?
But at that point of time, two group D staff were there. After the decision of the Supreme Court, there is only one.
So one has lost job. Stop.
SMC permitted for general transfer.
Stop. After stop. Transfer application on portal বললাম তো stop. Transfer application was forwarded by the state school authority বলে state school করে দেবে তো transfer application was forwarded by the state school authority to the concerned district inspector of schools AC, and thereafter transfer application reached West Bengal Central School Service Commission through portal on 29 September 2022 for taking final decision. Grievance of the petitioner is his transfer application is yet to be decided by the concerned authority of the commission. Next paragraph. School authority, said school authorities or said school is represented by learned advocate who has submitted after preferring transfer application on portal on 16 September 2022. School authority prior to 29 September 2022 accorded no objection for transfer of the petitioner. Since at the material point of time, there were 2 Group D staff in the school, including the petitioner. So, subsequently, 1 Group D staff has lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave petitions within brackets C number 9586 of 2024 within brackets State of West Bengal and others versus Chatterjee, Boishaki Bhattacharya Chatterjee and others, close bracket. So, at present, there is 1 Group D staff in the school, and if now at present petitioner is the sole Group D staff in the said school, and if petitioner is transferred, there will be no Group D staff. So, next paragraph. Having considered the submissions made on behalf of the parties, Secretary, West Bengal Central School Service Commission is directed to decide transfer application of the petitioner by 6 weeks from the date of communication of this order, after granting opportunity of hearing to the petitioner and the said school authority. So, decision to be taken by the secretary shall be communicated to the petitioner by fortnight thereafter. Shall be communicated to the parties by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Next. Leave is granted to the learned advocate for the petitioner to amend the cost title and add Secretary, West Bengal Central School Service Commission as additional respondent in course of this day. So, however, service of notice upon the additional respondent stands dispensed with, since West Bengal Central School Service Commission is represented by learned advocate. Next paragraph, writ petition stands disposed of.
In accordance with the transfer rules 2015, because the extraneous considerations are coming now.
Consciously, I have not stated so.
I understood that. That's why I'm submitting. Malad. In terms of the transfer rules, Malad, kindly. Malad, I submitted that. I understood what has fallen from your lordship. In accordance with law. In accordance with law.
That is not required to be specified
in terms of the rules.
No.
I rightly got you.
Yes, you have a right to urge this.
I understood. Great.
Produce it before the authority. I have recorded your submission.
Yes. Grateful to
Oh, document.
Item number 185 for monthly list.
এখানে কত অবধি হলো? এটা নিয়ে এটা চেঞ্জ করে দেবেন কি? এটাকে তুমি দেবে আর তুমি এই জিনিসটা দিচ্ছ না, আমি এটার উপরেই নোট করে যাচ্ছি। উনি দিয়েছেন ও
Passed an order. Single order may be passed here. For increment on expiry of 10 years and 20 years, there is a circular. Let's say direct.
For?
There is circular for 3% increment on expiry of 10 years and 20 years. That is yet
3% increment.
3%.
3% additional increment for manning the post of headmaster in a upgraded school.
Yes. On expiry of 10 years and 20 years.
That is one scale jump, not 3%.
I believe that
5524.
আমাদের কপি দাও। 55-34 আমাদের কপি দাও।
This is ROPA 2009.
And subsequent another memo, my lord.
Yeah, 10 years and 18 years benefit.
10 years and 20 years, if I'm not mistaken.
I have passed order in another matter. Show me that order.
Only in this case, I have expired my 20 years. Already let work for 20 years.
Assistant teacher.
Assistant. That were 10 years.
Oh, that there are several matters due to headmaster.
No,
It is happening for the headmaster.
That was the allegation made in the red petition also.
Other matters are also pending before this court.
Lordship.
In paragraph 12, it will be 20 years.
From which date you are working in this?
I have pleaded. Petition to those, please. That first paragraph of my red petition. First paragraph totally passed. Sorry, second paragraph.
When you have joined, appointed, video letter dated 2030, say appointment letter. Where is your approval of appointment? From there, but the name of the teacher, names of the teachers are different.
No, second. Second man.
What? Ali Abraham. August 2002. But in this, if I correct my previous order, in order to pass order in this matter, I have recorded that prior to that petitioner was working as an assistant teacher in another school. Is it applicable in this case? That the petitioner was working in another school?
Yes. Page flat. At 10 of my red petition blood, I have mentioned the previous school.
Page 10.
1-3.
1-3.
Yes.
But page 13 of the writ petition says petitioner was appointed on 7th November 2007. 7th November.
7 November 2007, but in the present school. And but previously he was serving that as
No, in the present school, that is Goaberia High School.
Yes, that is the
When petitioner was appointed.
But in 2007 he has joined.
Yes, that is 7 November 2007.
Initially he was appointed in 2000.
In the present school, petitioner's appointment is 7 November 2007. In previous school, petitioner was working from 23rd August 2002. 23rd August 2002.
Yes.
When you have completed 10 years continuous approved service,
That I have needed. 10 years I pay guys. But 10 years I have already, the benefit I have received. Now that I am expecting like 20 years benefit.
So now you are claiming 20 years benefit. এই শোনো এই জায়গাটা না এটার উপরে করে দিতে হবে এই জায়গাটা চেঞ্জ করে প্যারাগ্রাফ 1 এর এগেইনস্টে লিখে রাখো on completion of 10 years continuous service counted from 23rd August 2002
Yes.
petitioner received service benefits.
Instruction.
হয়ে গেছে
Instruction that after compliance of the objection by the school authority, the additional director of accounts AC Howrah raised objection once again on 11/7/25, which was communicated to the school authority through a letter dated so and so, which is not yet complied with by the school authority. Copy of objection dated so and so. The headmaster of the said school submitted a letter dated 30th of August 25 stating that the petitioner was communicated to submit the requisite documents, but he has not obtained the same from the petitioner, hence unable to comply the objection. This was my instruction from the DI lordship. আরে স্কুল তো সেটা বলবে অবজেকশন তোমরা দিয়েছো তুমি সেটা বলবে না একবার আগে জজ সাহেবকে অদ্ভুত বলেনি এইচারের কথা লেখেই নি
এইচআর এর ডিক্লারেশন
এসব পদে কিছু লেখাই নেই
এইচআর এর ডিক্লারেশন ওপেন 19 এইচআর এর
20,900
No, this is a separate issue so far previous matter is concerned. This matter is to be considered separately because in that writ petition, you paid for 10 years benefit and arrears under RUPA 19.
That is also same.
But in this writ petition, you are praying, you are submitting that 10 years benefit has already been granted to you. You are claiming 20 years benefit.
Same by same circular.
Yes, 20 years benefit that is to be considered because there are certain objections by the deputy director of accounts.
For my client on because in the HR. HR has nothing to do with my Travis.
But
Expiry of 10 years.
Yes, what is your instruction?
It appears, they just hand up there. Give it. Hey, Joseph.
They could come up with it. But the special objection.
This matter cannot be put in the same formula, which was followed by this court in previous occasion.
So kindly can take this one. Below third page is missing in that document, my lord. এটা দিও চাকরি দিন ওটা আর ওই চিঠিটা স্কুলের ওইটাতে ওই স্কুলের চিঠিটা That is, that third page is missing, that's what I am giving that. Same thing.
Just a minute.
Sorry.
ওখানে তো স্কুলটা প্ল্যান মিলে গেছে তো এটা নিয়ে ইন্টারেস্ট হবে না আমিও তো যাবো ভাবছি দেখেছি আসছি না যাবো
Yes, what is the objection in terms of letter dated 4th August 2025?
May I?
Wait. Paragraph 5.
Yes, my lord.
Because school has complied with the first objection.
Yes, my lord.
DI has said that the school authority submitted an area claim January 20 to February 20 in terms of ROPA 2019.
11/7/25 and 4/8.
JTAC Howrah raised objection several times during vetting.
My lord.
Then after compliance with the objection by the school authority, additional director of accounts AC Howrah raised objection once again on 11 July 25, which was communicated to the school authority through a letter dated 4th August 2025.
First page 1, my lord. With wanting complete service book, substantial appointment letter, ROPA 19 form certificate, B.Ed pass certificate, and HR.
So why these documents were not supplied? Service book, substantial appointment approval letter, then ROPA 2019 option form duly authenticated, B.Ed pass certificate and HRA declaration.
Yes, Lordship, I have submitted the entire document that, according to the memo.
11 July 2025. Yes, that is stated by, that is DI has stated that
After getting the.
no, but in terms of the memo dated 11 July 2025, whether you have responded.
Yes, again, I have been getting the requirement from the DI office on 4th August 2025.
Next page, my lord.
And on the basis of that, submitting entire on August 2026. This is the top news.
Second letter reply. The school's letter, my lord, I have that another document.
No, this is assistant teachers of others. I'm not concerned with this.
There is two things, Lordship.
Assistant teacher, other assistant teacher, I'm not concerned.
No, only petition.
Only thing 11 July 2025, whether you have responded or not.
Lordship, there is two things. One is ADR and another is ROPA. As far as the ADR is concerned, after getting the data from 2022, according to the circular, Lordship, the notice was by the
Court is not required to enter into this. Please show him the letter dated 11 July 2025.
After that, this is the comment.
Please show him.
And দেখো. And the school has been not
So he
দেখো এটা দেখো। আরে দেখেছি বল।
Lordship,
after getting this one thing document, I already circulated everything to the staff. But till date, they did not provide any document. Not only that, till to date, they never any communication to the agent. They never show it.
These documents are not lying in the office of the school.
Whatever document like with us, that also I already forwarded to the DI office.
What are those documents?
The document is area bill statement already given, Lordship. Once in 2022 and another is 2023.
No, that is the document in connection with all the teachers. Court will not enter into the issue of other teachers. Only court will confine itself to the petitioner only, relating to the claim of the petitioner where you have sent the document. How you have sent the document?
There is the entire requirement for entire school staff, including teaching and non-teaching. There are 13 staff, teaching and non-teaching. Entire requisition already sent by the HM to the.
That is not required. Only thing which is required is submission of documents in terms of memo dated 11 July 2025.
That they have not done, which will be evident, my lord, from the last document. That's why I have given another copy, my lord. This is this copy. The school's letter was not there. Kindly takes the last page. The school has expressed their inability to submit the documents. Kindly takes that, my lord. Information regarding non-cooperation of some staff related to area claim of the matter. Lastly, my lord, yes, as a result, the school authorities are currently unable to submit the documents requested by the DIAC and or assistant
You
director.
will have those documents. Mr. Ahmed, if you have these documents, I will permit you to appear before the DI, submit those documents.
Not only that, Lordship, I everything circulate with also WhatsApp group.
I will permit you that bypassing the headmaster, straightway approach the DI, submit those documents.
That is good line with the headmaster and accommodated that I can provide. Option form is also lying with the headmaster. VA certificate I have.
Very well, let me fix up a date where the headmaster and the petitioner will appear before the DI for concluding the
yes, complete in their formality
exercise.
Lordship.
And report is to be filed by the DI before Lordship. Read court will not do this all this.
No.
Matter is supplementary affidavit filed on behalf of the petitioner is taken on record. Petitioner claimed area dues for upgradation of pay. Now, area dues from January 2020 to February 2020 for upgradation of pay under ROPA 2019. Petitioner is an assistant teacher of Goaberia High School, Howrah. A communication dated 1st September 2025 of the District Inspector of Schools AC Howrah is placed before this court and same is taken on record. From the said communication dated 1st September 2025, it appears that there are certain documents which are required to be submitted before the district inspector, before the concerned district inspector of schools within bracket HC in terms of memo dated 11 July 2025 issued by the Assistant Director of Accounts, Secondary Education, Howrah. Stop. According to the state respondents till date, those documents in terms of memo dated 11 July 2025 have not been submitted. As a result whereof, area dues could not be released in favor of the petitioner. So, in order to complete the process of submitting relevant documents, headmaster of petitioner and headmaster of we school shall appear before the district inspector of schools AC Howrah, being respondent number
CI Millard, respondent
4,
number 4.
being AC Howrah being respondent number 4 on 17 September. 17 might be holiday. On 12 September 2025 at 2 p.m. At 2 p.m. At 2 p.m. Stop. At 2 p.m. along with all relevant documents and copies thereof. Stop. DI shall complete. DI shall make an respondent number 5 shall make an endeavor to complete the respondent number 4 shall make an respondent number 4 shall make an endeavor to complete the process for settling the claim of area dues of the petitioner in terms of ROPA 2019 on 12 September 2025 in presence of the petitioner and the headmaster. Stop. Respondent number 4 shall prepare a report and submit the same on the next date. Stop. List the matter under the same heading. List the matter under the same heading, or list the matter under the heading motion. List the matter under the heading to be mentioned on 23rd September 2025.
Grateful, madam.
Service benefit that has been mentioned.
Yes.
20 service benefit that is mentioned.
No, that is not apparent from the report of the DI.
That is also not given.
Only to benefits, area benefits under ROPA 2019.
So far, area benefits, they have this objection. So far, PTS service benefit.
আচ্ছা ওখানে ওই যে ডিআই এর কাছে অ্যাপিয়ার করবে না জায়গাটা পড়ো
সেটা হিয়ারিং এ হবে হিয়ারিং এ হিয়ারিং এ সেটা করবেন
the area dues in terms of ROPA 2019 and sanction of 20 years service benefit. Service benefit. Continuous or take back one memo, one communication. All the matters, interest and gratuity matters.
Item number 1433.
Yeah, for the state. Final revenue service, yes, assistant teacher.
Oh, departmental.
Retired on. Already 2020. Revised PPO. PPO date. Affidavit service filed. Headmaster, single PPO from the date following the date of retirement till the date of superannuation, 8%. Disposed of. Next.
Item number 1434.
Who is for the state? Retired on. Single PPO. PPO dated.
8 January 2021.
Headmaster, single PPO disposed of.
Item number 1435.
Yes, you are for the state. Assistant teacher. Retired on. First PPO. Revised PPO. Assistant teacher revised PPO 14 February. Disposed of.
Serviced. Item number 1436.
Yes. At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 1437.
Appearing on behalf of His State, Your Lordship, led by Ananya Nyogi.
At the time of call, no one appears for the petitioner and no accommodation is paid for. State respondents are represented by learned advocate. Next, writ petition stands dismissed for default. Parties to act on the server copy.
Item number 1438.
Time for the petition.
You have come from Jalpaiguri?
Yes. No, my.
Yes.
Well, petitioner husband retired on Monday, 13 November.
Assistant teacher.
Yes, ma'am.
Wife has come.
Yes, ma'am.
Husband was?
Assistant teacher, ma'am, retired on Monday, 13.
Who is for the state? Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Take in spite of service of notice, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 10 days from date and file by 10 days from date. Stop. Next part, list the matter under the same heading for further consideration in the monthly combined list of November 2025. Where is the notice? Only this challan.
Yes, my lord, notice, my lord.
And that was served on 11th March 2024.
Yes, my lord. Serving, my.
Old service.
Yes, my lord.
And with the wrong indication that a matter is to be moved before Justice Rajashekar Mantha.
My lord,
When Justice Mantha did not have determination.
Yes.
Justice Vishwajit Basu has had the determination. So that matter cannot be enlisted.
Yes, my lord, I am impressed.
We know these tricks.
Thank you.
It is out. Take back this affidavit of service.
Yes, my lord.
Learned advocate representing the petitioner prays for accommodation to serve notice upon the respondent. Let service of notice, let notice be served upon all the respondents by fortnight from date and an affidavit of service to be filed on the next day. This the matter under the same heading in the monthly combined list of November 2025. Give this affidavit of service. ওপরে দিয়ে দাও তো every service filed on behalf of the petitioner is taken on record.
Item number 149.
Same. Where is your affidavit of service? Nobody will appear. Who will appear for the state? Same order.
Yes, my lord, same.
Item number 1440.
Sir, I am for the petition. The total interest of gratuity, my lord, single PO.
Affidavit of service. The state is represented. We are for the state.
Yes, my lord.
When you your name was included in the panel of the state advocate. 18. Then it is all right. Yes.
My lord, petition was assistant teacher, my lord, retired on 30 November 2005.
And you are coming after 15 years.
Take profit that.
Retired on 30th November 2005. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner retired assistant teacher.
Yes, my
Petitioner retired on superannuation from the post of assistant teacher on 30th November 2005. And pension payment order was issued on 8 May 2005.
2006, my
2006. Stop. Petitioner filed this writ petition on 11th March 2024, comma. Precisely 19 years after superannuity. Next paragraph. There is no plausible explanation of delay. Next paragraph. Issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing puja vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next.
Item number 1441.
Assistant teacher. Group D.
Yes.
Retired on 28th February 2019.
2018.
28th February 2018.
Yes, ma'am.
Oh, state is not there.
I'm from the state, Your Lordship.
Single PPO.
No, my lord, revised PPO.
First PPO.
23rd March 2018.
Revised PPO.
16 June 2021.
16 June 2021.
Yes.
Yes, sir. In terms of previous order, notice is filed today and same is taken on record. Next paragraph. Group D staff, revised PPO, একটা জায়গায় করবে, তারপরে করবে state respondents are represented by learned advocate who appears on virtual mode. 14th February. Disposed of. Next.
Item number 1442.
Hold. Same.
The same order করে দেবে. Press affidavit of service to be filed. Next.
Item number 1443.
File your affidavit service. Same order. Monthly list of November. Next.
Item number 1444.
Same order.
Item number 1445.
Yes, same order.
Item number 1446.
How many matters do you have till which item? এই অর্পণ দাঁড়াও এই ব্যাপারটা করে নিই।
1454 item number.
1454.
Yes.
1447
1447. Yeah.
Same order.
My lord, I am appearing on behalf of the respondent, my lord, state 1447, I am appearing.
Yes.
1447, I am appearing, my lord.
Let it be called on.
My lord. My lord.
Item number 1447.
For the petition number.
একসঙ্গে হয়ে যাচ্ছে না।
When retired?
The petitioner retired on my lord 13 November 2016. Ropa 2019. Decided.
Assistant teacher?
Yes, my lord.
Retired on?
My lord, 30 November 2016.
Nothing is readable.
My lord, kindly.
30 November 16.
Yes, my lord.
First PPO?
My lord, 3rd November 2016.
Revised PPO?
My lord, 22nd March 2022.
22nd March
2022.
Assistant teacher revised PPO. 14 February. Yes. Next.
Item number 1448.
অর্পণ তুমি চলে যাচ্ছ এবার থেকে। Yes.
The petition for interest of revised. Yeah, assistant teacher, my lord.
Retired on?
My lord, 31st January 2020.
First PPO?
My lord, 19 February 2020.
Revised PPO?
My lord, 9 February 2021.
February 2021.
Yes.
Assistant teacher revised PPO. 14 February. 8% disposed of. State is represented. Next.
Item number 1449.
File a referee service. Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Client advocate for the petitioner prays for leave to file, prays for leave to serve notice upon all the respondents. Let notice be served upon all the respondents by fortnight from date. Next paragraph. List the matter under the same heading in the monthly combined list of November 2025. Next.
Item number 1450.
Old service.
Same order, old services. November 2025.
Item number 1451.
Old service. Same order, November 2021.
Item number 1452.
Same order, November 2025.
Item number 1453.
Then eight as per getting as per report 2019.
Yes.
Petition was the assistant teacher.
When returned?
Retired on my lord 31st January 2018.
80.
80. Revised PPO my lord report 90.
One under total. First PPO.
25 January 2018.
Revised PPO.
10 March 2021.
Assistant teacher revised PPO. 14th February.
Disposed of.
Item number 1455.
Service, November 2025.
And 1439 stage are there.
Next.
Item number 1455.
Date of 31st July 2030. It is within 30.
Now, have you served notice upon the state advocate? Date of retirement can be found from page 13. I believe it is 31st of July 2016. Yes. Retired on 31st July 2016. Single PPO.
Revised
First PPO.
9th June 2016.
Revised PPO.
11th December 2020.
Headmaster, revised. In terms of previous order, notice is served. Now, notice is filed today, showing service. Now, showing intimation to the learned advocate representing the state respondents. Next paragraph, in spite of service of notice, state respondents are not represented. হলো তারপরে যা আছে করছে হেডমাস্টার মাঝখানে ওই প্যারাগ্রাফ স্টেট রেসপন্ডেন্ট ওটা হবে না 14 February ডিসপোজ নেক্সট
Item number 1456.
notice টা notice served. Yes, assistant teacher. Do you have any doubt? In a confusing tone, you are submitting this. Assistant headmaster. Retired on
31st January 2002.
31st January 2020.
Yes.
First PPO
21st April 2020.
single PPO. 21st April 2022. And retired on 31st January 2020.
Yes.
Assistant headmaster আচ্ছা ওই নোটিশটা করে দেবে আগে ঠিক যেটা করা হলো বুঝতে পেরেছো ইন স্পাইট অফ সার্ভিস অফ single PPO assistant headmaster single PPO from the date following the date of superannuation till the date of release 8%. Did for the
Item number 1457.
Malad, I am for the statement.
Yes. Yes.
Petitioner was an assistant teacher.
Retired on
31st July 2019, my lord.
first PPO
26th July 2019.
No.
26th July
19.
revised PPO
31st August 2020.
2020
2020.
state represented issue মানে হ্যাঁ revised PPO কিন্তু in terms of previous record and order in terms of previous order notice is served notice is filed today and same is taken on record তারপরে assistant teacher revised PPO state respondents is represented by disposed next
Item number 1458.
yes
Revised PPO, my lord.
for the state
Revised PPO, my lord. Assistant.
notice you have served state is represented assistant teacher retired on
30th November 2017.
30th November 2017 first PPO
24 November 2017.
revised PPO
6 January 2022.
notice
State present.
in terms of previous order notice is filed today and same is taken on record তারপরে assistant teacher revised PPO state respondents is represented disposed of
Item number 1459.
Petitioner note.
notice oh primary or secondary
Actually, it is secondary. It is instead of wrongly typed as head teacher lordship.
where you have stated that primary teacher,
It is wrongly typed as headmaster.
head teacher.
Head teacher. It is
Where?
Paragraph 2, Lordship. Retired 33 years when he was head teacher of. In the PPO, it is written.
Previously, you served notice and that was filed on last occasion.
Yes, Lordship.
Notice upon the learned advocate representing the state response.
Yes, Lordship.
State advocate. Yes, yes. Headmaster.
Headmaster. Lordship.
Headmaster. Headmaster. Retired on
That on 31st January 2018.
first PPO,
In January 2018.
revised PPO,
9th October 2020.
it will issue. Client advocate representing the petitioner submits that petitioner was working in a secondary school. Therefore, writ petition needs to be treated. Therefore, the issue involved in this writ petition relates to secondary education. Secondary/higher secondary education. Next paragraph. In terms of previous order, notice was served upon the learned advocate representing the state respondents, and same is lying on record. Stop. In spite of service of notice, state respondents are not represented. তারপরে হেডমাস্টার ফার্স্ট পিপিও সেকেন্ড রিভাইজড পিপিও করে দেবে 14th February. Disposed of.
Item number 1460.
Notice. Yes.
Died on 13th June 2019.
Died in harness. Retired. Retired on
30th June 2019.
first PPO,
July 2019.
revised PPO,
11th August 2021.
11th August 2021.
Yes.
Notice in terms of previous order, notice served upon the learned advocate representing the state respondents is filed today. Top headmaster revised PPO, 14th February. Disposed of. In spite of service of notice, state respondents are not represented.
Item number 1461.
Lordship, I am for the state respondent.
Right. Upper 19 revised PPO. Upper 19 revised PPO. Revised PPO. Assistant teacher.
Petitioner was an assistant teacher.
Retired on
30th November 2019, my dear.
First PPO, 3rd December 2019. Revised PPO 21st December 2021. 2020. In terms of previous order notices filed today. Stop. Assistant teacher revised PPO state is represented. 14th February. Next.
Item number 1462.
Notice.
Yes. Revised PPO assistant headmaster.
Retired on
31st January 2020.
first PPO
27 January 2020.
revised PPO
7 April 2021.
notice filed. State respondents, in spite of service of notice, state respondents are not represented. Assistant headmaster revised PPO. Next.
Item number 1463.
What is for the state? Single PPO.
Revised PPO.
Yes, petitioner was
Petitioner was a headmaster, assistant headmaster.
retired on
it is died in harness. Wife has come.
say so.
Husband of the petitioner was the headmaster.
Headmaster. Just now you have said assistant headmaster. Died in harness.
Died 1st August 2021.
When in that event he died after retirement.
Yes, sir.
So they tell me the date of superannuation.
31st August 2016.
31st August 2016. When died? After issuance of PPO or prior to PPO?
After issuance of first PPO, Lordship. He died on
Just a minute. First PPO.
first PPO issued on 8th June 2016.
8 June 2016.
Yes,
Then died.
yes. He died on after revised PPO. Revised PPO issued on 28th December 2020.
28 December 2020. Then died.
1st August 2020.
Husband then died on 1st
August 2021.
where you have stated. Because it is not reflected from your PPO.
Paragraph. Paragraph 2, Lordship, that the date of retirement is there. Lordship.
Where you have stated that husband of the petitioner when died.
died on 7.
7. First August 2021.
Yes, sir.
Notice filed in spite. Notice filed in spite of service of notice, state respondents are not represented. Then wife has come, ওইভাবে করে দেবে। First PPO, second PPO, then husband died. 14th February 2020 at a rate of 8%. Disposed of. Next.
Item number 1464.
Serve notice in terms of earlier order method.
Notice served. File it. Yes.
This one was an assistant teacher.
Retired on
31st January 2017.
2017.
2017.
31st January 2017. First PPO
9th January 2017.
Revised PPO
20th September 2021.
20 September 2021. Notice filed in terms of previous order, notice is filed. Notice served upon the learned advocate representing the state respondent is filed today. In spite of service of notice, state respondents are not represented. Assistant teacher, revised PPO, 14th February. Disposed of. Next.
Item number 1465.
Notice.
Petitioner was an assistant.
Assistant teacher. Retired on
28th October 2018, madam.
No, 28th February 2018.
Oh, sorry. I'm sorry. 28th February.
First PPO
27th June 2018.
Revised PPO
6th August 2021.
6th August 2021. Notice filed in terms of previous order ভেবে করে দেবে। Assistant teacher, revised PPO, state respondents is represented. 14th February, 8%. Disposed of. Next.
Item number 1466.
Right. Level based, my lord.
Wife.
No, my lord. To communicate the notice, my lord. But could not serve my lord.
Notice could not be served.
No, my lord. So, number was not ringing also.
Assistant teacher.
Yes, well. Another assistant.
Retired on
Retired on 31st January 2016. Man.
First PPO
9th December 2015.
9 December 2015. Revised PPO.
10th December 2021.
Petitioner is not coming under ROPA 2019. Retired on 31st Jan. Oh.
Earlier.
Yes. Whether petitioner is coming under ROPA 2019.
The revised PPO issued on 10th February, 10th December 2021. My lord, I am praying for the revised PPO.
Issue. Client advocate representing the petitioner submits in terms of previous order. Effort was made to serve notice upon the learned advocate representing the state respondents. But due to non-availability of the learned advocate representing the state respondents, but due to non-availability, but notice could not be served. Next paragraph. Full name?
Lipika Chatterjee.
Lipika Chatterjee. Miss Lipika Chatterjee, MS. Lipika Chatterjee, learned advocate, is present in court, who represents on behalf of state respondents. Miss MS Lipika Chatterjee is requested to represent state respondents. Stop. Learned government pleader is requested to regularize engagement of Miss Lipika Chatterjee on behalf of state respondents. Next paragraph. Assistant teacher, so retired on 31st January 2016, first PPO, revised PPO. 14th February 2020, 6% disposed. 8% disposed.
Yes, sir.
Serve a copy upon him, upon her.
Item number 1467.
First time. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, now, in spite of service of notice, state respondents are not represented. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 10 days from date. Stop. List the matter under the same heading in the monthly combined list of November 2025. Take back the copy of the order.
Item number 1468.
For the petitioner, my lord. My lord, in this matter, my lord, the notice was attempt to serve, my lord. The lawyer, my lord, after receiving the call, he said, my lord, he is not representing the state, my lord.
Show me the notice.
But could not receive, my lord. Order.
You appear on behalf of the state. Your full name? সুব্রত দাশগুপ্ত। আচ্ছা, ওইভাবে করবে। Learned advocate representation submits that effort was made. এটা করে দেবে, করে তারপর সুব্রত দাশগুপ্তর নামে সুব্রত দাস।
একটা কাগজের নামটা।
Yes.
My lord, petitioner was an assistant teacher.
Assistant teacher.
Assistant.
Retired on
31st March 2020, my lord. Yes, revised.
31st March
2020, my lord.
2020. First PPO
16th March 2020.
revised PPO
7th April 2021, my lord.
7th April 2021.
1468.
7th April 2021. Assistant teacher revised PPO 14th February 2020. Disposal.
Item number 1469.
Assistant teacher,
Assistant teacher
single people. Item.
retired on
31st of March 2018.
PPO date
7th March 2019.
single PPO.
Single people.
Assistant teacher single PPO. State is represented.
Statement.
Please put it.
My lord, kindly, my lord.